With the consent of the other side, I mentioned item 31 of today's daily dispute. I'm for the respondent. 31. It's, my affidavit is ready, my lord. I'll file it by Monday. Mr. Sharma is here for the petitioners, my lord. He has asked for if possible, a date to be given.
Maybe on 8th of June, sir.
8th of June.
8th of June.
At the request of the learned counsel appearing for the parties, list the matter on 8th of June. The learned counsel for the respondent assures that the affidavit in response to the writ petition will be filed prior to the date.
And we'll file a reagenda also.
The petitioners would be at liberty to file their reply.
Applies.
Yes, sir.
My lord, item number 15, the petitioner, 15. The petitioner has filed another writ petition which is listed on Monday. May I please this matter also be come up with that matter?
At the request of the learned counsel for the petitioner, list this matter along with WPC number
2688 of 26.
on Monday. Monday key date side.
And another request, my lord, regarding item 53 and 54. In item 54, we have filed an entitlement application. So let it come for orders for first entitlement.
Learned counsel appearing for the petitioner submitted that a petition for impediment of parties has been filed in the matter. However, the same is not on record today. Is this matter again with the impediment IA
1602 of 26. 02 26
of 26 in the orders column.
Obliged.
May it please, your Lordship. Lordship, I beg to mention for upgradation item number supplementary 56. Lordship, this is that IA, my lord, had fixed it today, my lord, for further hearing, my lord. Can be taken up at 2 o'clock, my lord, if possible, my lord.
Okay.
Supplementary 56.
Have the other party here?
I'll have informed them. I've informed them.
Have someone sending?
Well,
Yes.
Item number
PPF.
37. Item number 37.
37.
37, madam.
Yes.
The pleadings have been completed, my lord. I filed the reply. I have some difficulty today, my lord. Let the matter come up next week, my lord, subject to your lordship's convenience. If the matter pertains to compulsory retirement, I've taken consent from Miss R. Devi, my lord. My lord.
Okay, at the request of the learned counsel for the petitioner, which is not opposed to by the learned counsel for the respondent, list this matter again on.
I'll leave it to your lordship's convenience, my lord.
Bondra, got it? 11.
My lord, I'm grateful, my lord.
May I please, your Lordship? I beg to mention item number 35, your Lordship. Lordship, this matter may come up before any other bench, your Lordship.
List this matter before any other bench without me.
Lordship, I beg to mention item number 28, Lordship.
28, yes.
28. In this case, Dibrugarh University is a party respondent. The matter may kindly come up for.
Is that so? So we'll give up the education bench?
No, Lordship. Actually, I thought.
We will not take any matters related to education at his request.
Lordship.
Was I involved in that matter?
Yes, Lordship.
Are you sure?
Yes, Lordship.
I was in the matter.
Yes, Lordship.
List this matter before any other bench without me. Before a bench without me. Any other bench before a bench without me.
Lordship. Much obliged.
Yes.
May I please, your lordship, may I make a similar plea in respect of item number 42?
42.
Yes, your lordship was engaged in that matter, lordship.
Okay.
Obliged, lordship.
We keep every matter not before us. We'll change the bench. Yes.
It would be better if your lordship takes up civil bench too.
He says we were sending counsel there.
Lordship.
Yes.
I beg to mention item number 14. Possible for that.
The request has to be a bit more enthusiastic. I'm able to hear you.
Item number 14.
1-4.
1-4. Possible for that day.
Why? It's in the mediation report. Mediation failed.
I have no
no idea.
instruction.
I'm appearing on behalf of the respondent number 4.
Mediation failed.
So,
No idea.
also with that maybe fix next week.
Next week, detail. At the request of the learned counsel for the parties, list next week. 2nd of June. Yes.
This was notice was issued.
My lord, service is awaited, my lord. We get some accommodation. We take the notice, instruction, my lord, regarding the notice.
You are behind bars.
Yes,
when?
my lord. Almost 10 months, Lord. From last 16 July, Lord. Earlier, he was released on bail, Lordship. Thereafter, NBW was issued. Thereafter, he noticed someone was issued from the court, and due to some, because he was not available in the home, thereafter, NBW was issued
He was earlier on bail.
on bail, Lord.
And then after the charge sheet was submitted,
Submitted,
summons were issued, he did not appear.
He was not in the home, Lordship.
He did not appear,
Appear.
and therefore he was arrested again.
Arrested.
And now he's behind bar for
Behind
debt
the-
reason.
Already informed.
But
And
Mr.
his
Arhak,
victim
learned
already
counsel
examined.
appearing for the petitioner. This one so appears for the as the additional public prosecutor. Full stop. Notice on the respondent number 2 was issued. Was directed to be issued on 6/5/2026 and steps were taken on 12/5/2026. Full stop.
12/5/2026.
Learned APP submits that the service of that the report on service of notice is awaited. Office note reflects that the scanned copy of the trial court records have been received.
Yes, ma'am.
Okay. The learned counsel for the petitioner submits that the petitioner was allowed the privilege of bail during the period of investigation. But on his failure to appear before the learned trial court after issuance of summons, on the ground that he was not available at his home to receive the summons, on his appearance, he was taken. On his appearance, or he was arrested.
Arrested on NBW.
He was later arrested and has been suffering custody,
From
suffering detention
16/5/2025. 16/7, sorry.
16/7/2025. Stop. In the circumstances, this court deems it fit to appoint an amicus in the matter, amicus on matter detail. Accordingly, so and so is appointed as the amicus. Learned counsel for the petitioner.
2 and 3, Lordship. Second and third, Lordship.
Second and third, I'm not understanding.
Second or third June, Lordship.
Wait for the order to be complete. You are jumping on the. Accordingly, so and so is appointed as the amicus in the matter. Learned counsel for the petitioner shall serve a copy of the application on the learned amicus. Full stop. In the meantime, the learned APP shall endeavor to have this notice served upon learned APP shall
Inform.
have his instructions on the service of report on the respondent number 2. Full stop. It is made clear that if the respondent number 2 appears through an advocate, through a counsel, the same shall also be allowed. Placed again on 2nd of June. 2nd of June. We are appointing an amicus so that at least on the next day we can do
If
something.
they from their side.
Because this is not a case where you
Yes,
are opposing on the
earlier, as because bail
on
granted.
bail.
Yes, ma'am. Oblige.
Huh? Dr. Pooja Agarwal. Oblige. Dr. Pooja Agarwal didn't take it. ठीक है.
The order is taken.
Execution petition.
Contempt petition.
Contempt petition.
They have the conducted hearing, but
When
the
did you
order
serve
is
the copy?
annexed 2 page 11.
When did you serve the copy?
It was sub long back, my lord. They
When?
have conducted hearing.
When?
Hearing, my lord. I have not annexed
Wait.
annexed my lord, notice. Notice. It was received prior to that. It was not hearing was
The court order says 2 months from the date you serve a
yes.
copy. When did you serve?
The sub my lord, long back.
Otherwise, in compliance of the order, they are holding a hearing.
And order is
Therefore, no Disobedience.
Order is not passed.
What order? Maybe. You did not comply your part.
And
What is there, Harry? Unless you comply your part.
On our submission only, my lord, they have
Show us one sentence.
sentence, my lord.
One sentence that
that
you had given a copy of the order upon the respondent number so and so.
Respondent number two I have submitted, my lord.
Where?
And on the basis of my submission, they have
Where?
issued
Where?
that is not annexed.
Show me from the sentence. Show me a submission. Show me a statement in the contempt petition. Was it not specific? You will give a copy?
Yes, we have given.
Where is it? Where is it?
In paragraph 2, I have just written, my lord, whereby the Honorable Court has allowed the petitioner to file a fresh representation before the DESM for stating her grievance and directed the directorial investigation to carry out the hearing and complete the hearing within a period of 2 months from the date of receipt of the representation.
Which representation?
As per the said order, the Honorable Court, the directorial investigation has conducted the hearing on
Para
Saturday.
7. From the date of receipt of representation by the director from the petitioner. What is the date of your representation? So just show me that.
Date of, I could not.
Nothing. You have not said you have made a representation.
No,
You have not said you have served it.
That I
You have
can,
not said this is the date on which he received it. Therefore, 2 months will end on this date. Is it?
that I can give.
Will be running around with the whole department.
No. That
This court will be engaged with the whole department. Yes, sir. When did you receive the notice? Yes, sir. When did you do this? Yes, sir. When did... That is what we are going to ask them.
that
Preliminary, where is it?
I will give.
Tomorrow. Monday.
Monday, sir. Monday or virtual, next date, Tuesday.
Have an additional affidavit.
Yes.
This is the date I have
Additional
given.
affidavit, or I can give the, my lord, the date also. I can bring the date. They have submitted application. I can bring the date.
Bring it in 15 minutes. Call them up, bring it in 15 minutes. We'll issue notice.
Right.
Okay. That will be necessary because we are drawing contempt.
Yes. The date I am giving.
We will not be lenient. If the contempt
the
is
date I will give, my lord.
all of you said. Contempt 2 copy থাকে জানো? Contempt 1 copy থাকে। এইটো যোৱাকালি কোনবা এটা কেছ হ'ল।
May please, Your Lordship.
Yes.
Lordship, please come to Annexure 8, Lordship.
Annexure
8.
You have to give me the page, sir.
Starting page number, Lordship, 59, Lordship.
DB covered.
Yes, Lordship. It's 6% yes direction.
When was the DB order?
Lordship, 24/3/2026.
And what were you required to do?
Lordship, petitioner seek the similar protection and direction from this honorable court.
Page 66, second paragraph.
Page
Page 66, second paragraph.
You had applied.
Yes, Lordship.
Then you said that you had the 18 months DLN. By this page 40, you said these are the documents required.
Yes.
Division bench has said you will verify all the testimonials and whatever documents they cannot produce out of these 6 documents, you would verify with your database. And if the database, if they are found correct, they go ahead. If they are not found correct, you will tell them why. That is the issue.
Yes, that is what.
We'll dispose it of.
Yes.
Heard.
Yes, you see.
The counsel appearing for the petitioner. Also heard Mr. B. Kaushik, learned counsel appearing for the
Respondent number 1 and 2.
1 and 2 CGSE. Ms. Pukan appears for the respondent number 3 NCT. None. Respondent number 4 and 5. Although not represented today, comma, in view of the orders that are proposed to be passed, comma, their presence at this stage may not be necessary. But your repetition says Jugita Thakuria and another.
Yes, Lordship.
And you have three petitioners.
Three petitioners.
So how is it Jugita Thakuria and another?
So it's
You are cutting out the petitioner, adding two words in the other. Huh?
Lordship.
We'll give it for two. Which to choose?
Another two, Lordship.
Another two. The petitioners claim to be teachers. You are teachers?
Yes, Lordship.
No, petitioners claim to have participated in the reselection process initiated by the respondent 1 and 2 through an advertisement dated 26/12/2023 for filling up posts of assistant teachers in
Primary.
lower primary and upper primary schools. Full stop. The petitioners are aggrieved by the notification dated 17/6/2025 issued by the respondent number 2, whereby it was prescribed that the mandatory appearance of candidates who have submitted their online applications within 18 months with 18 months DLED obtained from NOS against the advertisements were required to produce the following documents. Take a set. Go to page 40. List of testimonial and document mark A pra A leke mark ke diso, huh? The learned counsel for the petitioner submits that some of the documents which have been sought for are not available with the petitioners, since neither are they the custodian of the same, nor do they have access to such documents. Full stop. The learned counsel for the petitioner has drawn attention of this court to the order dated 24/3/2026 passed by the division bench of this court in writ appeal number
345
of 2025, wherein a similar issue had been taken up and the following orders were passed. Full stop. You go page 65 or no, sorry.
Yes, 66.
You will start at page 65 of my able issue. Page 67 or last of the order. Huh? The learned counsel for the petitioner has submitted that in case the respondent authorities are directed to process the application forms of the petitioners for further participation in the selection process in the manner in which the division bench of this court had directed the respondents to adopt for the appellants in WA number so-and-so, the grievance of the petitioners for the present would be redressed. Stop. Mr. B. Kaushik, learned counsel, appearing for the respondent number 1 and 2 have submitted that the process of verification cannot be an unending, cannot be a never-ending process, and intermittent appearance of parties with to have their cases verified and processed would cause a delay in the entire selection and appointment process, full stop. It is noticed that the orders by the division bench were passed on 24/3/2026, requiring the respondents now expecting the respondents to carry out and conclude the process of verification, etc., within a period of 3 months from the date of the order. Full stop. Since the petitioners have already participated in the initial part of the proceedings, and the process of verification is yet to be completed, and the time frame process of verification and the time frame given by the division bench of this court in the writ appeal is yet to expire, we deem it fit to allow the prayers of the writ petition of the writ petitioners to the extent that they would also be entitled to have their cases verified by the respondent authorities. Full stop. As such, this writ petition is disposed of, directing the writ petitioners to, what are you required to do?
Submit the documents, those which are
To approach the whom?
the director of elementary.
To approach the respondent number 2 within a period of 7 days from today, along with all the documents that are available with them. Full stop. The respondent
Enlisted document as per the notification dated 7.
all the documents which are available with them from the list given in the notice dated 17/6/2025.
17/06/2025.
Full stop. The respondent authorities shall thereafter verify the documents to submitted and process the case of the petitioners for consideration for selection, along with the appellants in WA number 345 of 2025.
Yes. 2025.
If 7 days, it could be 15 days, Lordship.
The order was of March.
Briefing process is not
April.
started till date, Lordship.
It is till April. They are continuing the process. These documents have to be verified from the NIS and the NCT. 3 months given. You slept. On the ground of delay and lectures, you can zip it up. Take 7 days, do it. We will not cross that 3 months period. Anybody who comes prior to 3 months period, list this matter before a bench with me. Yes, sir.
Petitioner, sir, lecturers, assistant professors in the Ahmedabad College, aided college. They have been working since 2010. And the subjects were open with the approval of the Gauhati University Executive Council. It was sanctioned by the state government to open it. And they continued. State government has issued a circular, not a circular, it is a letter addressed to the principals of the government and other colleges. That your lordship will find at page.
Once. Oh, that one.
26.
At 26, yes. Dear states, my lord, not to appoint officers and contractual and other employees. And there also they stated those who are contractual employees should be dismissed or eliminated.
Terminated, huh?
But petitioners were not contractual.
They were what?
They were assistant professors temporarily
Regular?
appointed, Milord.
Regular?
Not regular,
Then?
because college, aided college, Milord, the regularization is in a phased manner. This is done. Appointment letter, you're also find at page 18. In one. DP resolution letter demand you are here appointed as lecturer in the Department of Arabic in Hamidabad College, Satya, with an LM sum per month. Temporary, they may be terminated. That's an unit reason. That is everywhere is there. And they continued.
But then you were released in the month of April itself.
Yes. On 17, the government order was issued, and on 24, they said, I am terminated. Terminated, Milord, working there, termination has to be proceeded by the notice.
This is a what? Provincialized college? What college?
No, aided college.
Aided college.
Aided provincialized college, yes. Aided college, they say.
Huh?
And the appointment and discipline is under the DB, not with the principal. Principal has no authority.
The issue is, will it fall, does it fall, would the rate code be? Huh?
Milord?
If it is between the GB and the.
No, GB's power has been reserved by the principal.
If it is not a provincialized college or a government college, should we be interfering
No, it is.
in a private college?
That is what I tried aided college, not a private
find
college.
out. There is nothing.
Not a purely private college, it is an aided college.
We find nothing here in the writ petition.
Regarding?
The nature of the college. Whether we can issue, whether we can take up a writ petition.
Aided colleges are
Article
coming to court
226.
below.
No. If it is a
Because
college,
everything is paid by the government.
the salaries are paid by the government.
My lord.
Cannot be.
Aided college.
You are at paragraph 8, page 8 at the top. You are saying that the it's a non-government college.
Yes, non-government management rules cover.
When will it cover? It will only cover non-government colleges.
Aided colleges are also covered by this law.
Is it? I don't think so.
Definition says college means Assam provincialized colleges and non-government colleges. Of the Act, management rule, at page 438.
38.
Of the management rules. It covers provincialized colleges and non-government colleges. Both.
It covers both.
Yes. And it is a government order, against a government order I am coming. Exercising jurisdiction on the basis of that order, my lord.
You see, an amendment has been made and they have not changed the name. At page 438, these rules may be called the Assam Provincialized College and Assam Non-Government College. But they have retained the name.
Yes.
Assam Non-Government College Management. That is why the confusion. Yeah. But Mr. D.P. Cholihal and its senior advocate assisted by
Right.
M. Royal and a counsel appearing for the petitioner. Also heard.
I think it's a
Representing
provincialized
counsel.
college, man.
Higher Education, Mr. S. Das. The grievance of the petitioner in this writ petition is the termination of his service as an assistant professor from the Ahmedabad College, Satya, to the order dated 24/4/2026. The learned senior counsel has submitted that the aforesaid order had terminated the services of the petitioner in compliance of the directive received from the Director of Higher Education.
Commissioner, my lord. Commissioner and secretary.
The letter says it is on the instructions of the director.
Letter says, my lord, but
The learned senior counsel
from
has
the director,
submitted
they
that
say.
the directions of the Director of Higher Education were based on the order dated 17/4/2026 issued by the Commissioner and Secretary to the Government of Assam, by which the government had directed that in case of any contractual staff presently engaged, the institutions were required to take necessary steps to discontinue such engagements in accordance with the applicable rules and contractual terms, ensuring that due process is followed. Full stop. It is not a provincialized college.
It is a provincialized college, madam.
Or is it a aided?
Provincialized college.
Aided and provincialized would be different.
My lord.
Aided.
How do you say it is provincialized?
I found a list, my lord, in it just
When
now.
it is a provincialized college.
Out of 295 colleges, this college name of the college is also there, my lord.
Is there provincialized college? The learned counsel for the learned senior counsel has submitted that in accordance with the termination of the petitioner is not in accordance with the Assam non-government educational institutions. What is that? Assam non-government college management rules 2001. To notice, returnable 4 weeks.
I have paid for 3 million. And may I pay that?
We will keep it subject to outcome of the writ petition because you were already terminated.
That is true, but the order is. Termination is there, but this is palpably legal.
Judgment saying
has
that
not been followed. It's like provincialized.
There are judgments which we have gone through which says that once the termination is effectuated, there cannot be a stay. There can be a reinstatement.
That is true, Miller.
Amounts to fine.
I'll take steps by dusty service, Miller.
We will allow that also.
3, 4, and 5.
The respondent number 1 and 2 are represented by Mr. S. Das, learned standing counsel, higher education.
One is my friend is appearing, madam.
Oh, one would.
I'm appearing for 2 only.
You say respondent number 1 is represented by Ms. K. Fukan, learned counsel, learned government advocate. Respondent number 2 is represented by Mr. S. Das, standing counsel, higher education department. Petitioner shall take steps for service of notice on the respondent number 3, 4, and 5 by usual process, and the petitioner is also allowed at the prayer of the learned senior counsel, take steps by dusty upon the respondent number 3, 4, and 5.
3, 4, and 5.
Step. Upon service of notice, the petitioner shall file an affidavit regarding the service of notice. List again on July, did you reopening it? List again on Swensu, the termination of the petition shall remain subject to outcome of the report. 24th of July, sir.
Please, Lordship. This is a second round of litigation, Lordship.
Second round.
Second round of litigation, Lordship. The content of the case is that during submission of staff pattern, the respondent authority wrongly submitted the staff pattern, showing my name as science teacher and science teacher as Hindi teacher. I am holding the post of Hindi teacher. That's why my service of my provincialization is deprived, Lordship.
What happened in the first round of litigation, sir?
First round of litigation, Lordship, can kindly come to page number 46, 45, Lordship.
Page 49, you were considered. Then what happened?
Thereafter, Lordship, Director of Elementary Education, Vice Order, Lordship, first of November 2025. My pair is rejected, Lordship.
Why?
They said that as per 2017 Act, Lordship, for provincialization additional teacher, enrollment criteria is mandatory, Lordship. Due to that reasons, my provincialization has been rejected.
Any case of a suo motu contempt, sir? Kindly come to page 49.
I've seen.
The court had come to a conclusion that 2011 he missed the bus because it was wrong. 2017 you are trying to introduce that number of students. No. The effect will be from 2017.
Yes, that is what page 49 Milot has conferred a right.
No review, no appeal. You have proceeded to decide the matter. Could you have decided in this?
No, but the the decision which has been taken perhaps is not in conformity with the judgment, because the state has taken a stand in that earlier petition that there was a mistake in the
Everything false. You will get the benefit from 2017.
Yes. But in respect of perhaps he is a case in respect of his first prayer for setting aside this speaking order.
So that actually happens, isn't it?
Yes,
that has to happen.
That has to happen. In respect of the other prayers, that he is seeking a benefit under the 2011 and in terms of Nur Islam or morally sake, he doesn't fall within it.
Not only that, Punavati Brahma will totally cover him.
Yes.
That was not set aside.
No, that is not set aside. But however, morally sake, there was a, in one paragraph it is said that once the district scrutiny committee has recommended that
He was never recommended.
He was never, he is not recommended.
You were recommended by the DA.
No.
You said that your name was not sent.
No.
Recommended, Lordship. It is reflect from their order, Lordship.
Where?
In their rejection order, kindly see.
Page 51. My lord will kindly see page 51. Last line, my lord. The government sanctioned the post for provincial teaching and non-teaching on the strength of the government sanction, the so-and-so, wherein Digento Tayed was shown as Hindi teacher and the post meant for science teacher was shown as vacant.
Now, now come to the first paragraph.
That is this for provincialization of the teaching center as amended in 2000. Digento Tayed, Hindi teacher, and Gunavati as science teacher.
Findings.
Yeah. No, the SLC
did not do it, but the DLC did it.
No, DLC has recommended. SLC has rejected him, saying that he did not have the.
Morally Sheikh says that if the DLC had rejected, forwarded him, then he had a right.
But SLC rejection of the SLC then, my lord, he has never put to challenge.
Kindly see the paragraph, page 48, Lordship. Paragraph 10, order, earlier order, Lordship. Last line, Lordship. This is submitted by the District Scrutiny Committee that concerned the Deputy Commissioner. Revised proposal had been sent to the sent with the recommendation of the level scrutiny committee to the Director of Elementary Education for correction of the name of the Hindi teacher. That from the last line of the page 48, Lordship.
Any private parties?
No, the provincialization of private respondent Arrear case, Lordship,
Has already been withdrawn.
Lordship. But my name is not corrected. His provincialized has withdrawn. But in earlier petitions, my prayer was that for correction on my name.
Mr. M.K. Nayab, counsel appearing for the petitioner. Mr. B. Kaushik, Learned Standing Counsel. Elementary Education Department.
My lord.
Appears for the respondent number 1,
1, 2, 3, and 1, 2, and 3.
And 1, 2, and 3. You'd appear, Ms. Fukan. Ms. Fukan appears for the respondent number 4. Learned Counsel for the petitioner has submitted that the petitioner is aggrieved by the order dated 1st of November 2025, passed by the Director of Elementary Education. By which the claim of the petitioner for provincialization of services was rejected. Full stop. The Learned Counsel for the petitioner has submitted that in an earlier round of litigation, this court had directed the respondent authorities to the Learned Counsel for the petitioner has drawn attention of this court to the order dated 4/2/2025, passed in WPC number 4067 of 2023, which was a writ petition filed by the petitioner herein, being aggrieved by the non-consideration of her case for provincialization under the, where is the full act name? Under users right under the Act of 2011, under the Act of 2011, you will find it at page 49. I have underlined, Upon consideration of the case projected by the petitioner, this court had passed the following orders from page 48, para 9, para 10, 49, page para 11, 12, 13, and 14. The Learned Counsel for the petitioner has submitted that in view of the orders passed by this court, the respondent authorities were required to verify whether the petitioner would have been otherwise eligible for provincialization under the Act of 2011, and if found to be eligible, the provincialization was to be given effect to from the date of coming into force of the, this is the second Act of 2017. Okay, you'll also find it in page number 49. The Learned Counsel for the petitioner has submitted that the rejection of the case of the petitioner on the ground that he did not fulfill the eligibility criteria under the Act of 2017 is in direct contravention with the orders passed by this court in the earlier occasion, and therefore the order dated 4/11/2025 requires an interference of this court. Full stop. Issue notice returnable 4 weeks since issue notice returnable 4 weeks since all the respondents are represented, no formal notices are required to be issued. No formal steps are required to be taken. Full stop. Petitioner shall serve extra copies of the writ petition upon the Learned Counsel appearing for the respondents within a period of 7 days from date. Respondents would file their response on or before the next date fixed. List again on what time, sir?
As your lordship pleases.
4 weeks. After 4 weeks, take a date.
Maybe after the vacation then.
Will I did you look at this? 14th of July.
Lordship.
May please, Your Lordship. But the matter is the non-release of my lord, the Arrear salary, my lord.
Yes.
Proposal has already been submitted, my lord, by the,
Proposal has been sent.
yes, my lord. Page 105.
Let notice be issued, my lord. I'll take instruction or instruction.
Once we issue notice, what happens is,
Yes, or
pendency of a case, we are not proceeding with the proposal.
Lordship will observe that pendency shall not be a bar.
Heard Mr. R. Sharma, learned counsel, appearing for the petitioner. Also heard Mr. P. Kaushik, learned counsel, appearing for the respondent number
1, 2, 3, 4, 5. 1 to 5. Sorry.
1 to 5.
Yes, 1 to 5.
Finance. H. Olia, counsel, inform. Mr. H. Olia, learned counsel, appears for the respondent number 6. This writ petition has been filed claiming disbursal of arrears salaries for the period from
1/11/2020 to 28/2/2021.
1/11/2020 to 28/2/2021. Mr. Abdullah, counsel for the petitioner has submitted that although proposals have been sent,
105.
have been forwarded, however, the payment of salary has not been made. Issue notice returnable 4 weeks. Since all the Mr. Kaushik accepts notice on behalf of respondent number 1 to 4.
4.
5.
4. 1 to 4.
Or 5.
5.
1 to 5.
5.
Comma. Mr. Choliha appears for the respondent number 6, therefore no formal steps required. However, petitioner shall serve extra copies of the writ petition upon the learned counsel appearing for the respondents within a period of 7 days from today. List again on
For vacation. 4 weeks.
15th of July 2026.
Pendency may not be a bar.
It is made clear that the pendency of this writ petition shall not be a bar for the respondents to process the payment of the arrears salaries to the petitioner.
Problem.
We'll keep it like this, Mr. Kaushik. We'll
If
keep it
found
like this.
delayed.
No, we'll keep it like this. The filing of this writ petition shall not be constituted by the respondents to be a bar to further process and pay the arrear salary of the petitioners, comma, if found entitled. Yes.
I'm saying pass over, pass over the timing.
Timing.
Take over argument.
What is it, madam? What is the matter?
Petitioner claiming that she has applied before the authority to include her name as nominee in the pension papers, Lordship, and applied, but authority disposed that application as because petitioner's husband never include her name in the pension paper, Lordship, as nominee, and therefore we have filed affidavit, our affidavit, and annex husband of the petitioner, annexer 2, page number not here.
Now, this is for the pension with the petitioner, the husband of the petitioner expired.
No, don't know now.
Eh?
This affidavit is filed on 22, Lordship, 2022. Petition.
Why is the husband not including her name?
Yes, Lordship.
Why is the husband not including her name?
That is not
Oh, you
mentioned.
have to find out.
Yes, Lordship.
Huh?
We have filed our affidavit 22. At the time of writ petition, filing of writ petition, the petitioner had not mentioned here that her husband were alive or not. Only her contention is that to include her name in the as nominee, Lordship. And to pray for disposal of the representation, and that representation has already disposed of by the authority.
None appears for the petitioner on call. Heard Ms. S. Borua Lanet. Counsel appearing the respondent number 1, 2, and 3. The prayers made in this writ petition were for inclusion of the name of the petitioner in the service record of her husband as a nominee to the service benefit in the absence of her husband, full stop. The affidavit in opposition had been filed by the respondent number 3. By contending that the nominee of a government servant is to be proposed by the government servant himself, and the inclusion of the name of a nominee in the service records cannot be done at the instance of a person who has not been identified as the family member and on a wife and or any other family member by the service holder, full stop. The aforesaid contention of the respondent authorities have not been rebutted by the petitioner, and petitioner has also failed to enter appearance today. The prayer of the petitioner for disposal of the representation filed by her has already been attended to by the respondents by the order dated
Communication made on 6/4/22 and 11/2/21 order.
by the order dated 11/2/2021, and the affidavit in opposition also contains a communication to the husband of the petitioner to submit the nominee along with relevant documents for inclusion in the service sheet, full stop. There is no representation from the petitioner to inform the court whether the relief sought for has been granted, full stop. However, it appears that since the respondents have taken steps to dispose of the representation of the petitioner and has also taken up and also had directed the husband of the alleged husband of the petitioner to give the full details, this court is of the opinion that nothing survives in this writ petition for further adjudication, full stop. Accordingly, the writ petition is closed. However, the petitioner shall be at liberty to approach the respondent authorities in case her grievance has not been addressed to by her husband by proposing her name as a nominee in his service records. Writ petition disposed of, no costs.
My lord,
on the last occasion, there was a direction to giving us liberty to file the affidavit. Well, we have filed it today. There was some delay in communicating therefore there was delivery. We have filed the affidavit today. We've served a copy to him, my friend.
Let it come on record.
Let it come on record.
Matter will be listed next week, Lordship.
Next week, I may not be here.
We'll have it on the first week of June.
Lordship.
But Mr. Malakar Learned Counsel, P. Malakar Learned Counsel appearing for the petition. Also heard Mr. P.K. Roy Learned Senior Counsel appearing for the respondents with the assistance of
E. Chakravarti.
The Learned Senior Counsel has submitted on instructions that the affidavit in opposition, that the required affidavit has been filed today. And therefore please that the matter may be listed in the first week of June, along with the affidavit filed. Full stop. The Learned Counsel for the petition has acknowledged receipt of the copy of the affidavit filed. Accordingly, release this matter again on 5th of June, along with the affidavit filed by the petition.
Lordship, this matter relates to that non-payment of my pay as assistant engineer, Lordship. Lordship, the respondents have filed an affidavit.
When?
It was filed long back, Lordship.
13/6/2025.
Yes, Lordship, 4th of June 2025, Lordship. Lordship, therein they have contended that I am still working as a junior engineer. That is the first point at paragraph 5. And then in the second paragraph, sub-para, Lordship, they have said that the additional Deputy Commissioner Borpeta was authorized to handle the financial power of Borpeta Municipal Board. And at that point of time, since there was no staffing pattern in Borpeta Municipal Board, Lordship, the pay was not disbursed, Lordship. Now, this query was raised and in order dated 15/9/2025, Lordship will find this query was taken care of, and in order dated 18/9/2025, it was clarified by the council from the state that the financial powers of Borpeta Road Municipal Board stood restored. 18/9/2025, second para, Lordship. So now, that ground that the staffing pattern, and one more thing, Lordship, I filed a reply wherein, Lordship, I have at paragraph 5, it was stated that in spite of that staffing pattern not being there, the other incumbents who were promoted in the meantime were granted the financial benefits, Lordship. I have been singled out, Lordship. Page 47, paragraph 5, it's there, Lordship.
There was some additional affidavit filed by the board.
Now, the board, since this 18/9/2025, the council for the board took time on the plea that, Lordship, the board will take a decision with regard to paying me, Lordship.
You have not been given a copy of this resolution which was
I have that, Lordship.
27/2/2026.
Yes, Lordship. It says basically in this second resolution, Lordship, the first line reads that there is, Lordship, I'll read that, Lordship. Mohammed Gauhati Usso Nyalo WPC number so and so number Gusor Bikoitu Obhat Uthapon Huat Alusona Morme Hiddanto Lua Hoise Bikoitu Zihetu Mohammed Usso Nyalo Visardhin He Adalotor Rai Onuhori Bebosta Grohon Kora Hobo. The second line is Obviously Hobhai Mot Puhon Kore Je Jihetu Borpeta Road.
Yes, sir, why are you denying them?
Lordship, I have some information regarding this, Lordship. As per the government order dated, it is May 21, 2009, are instructed not to make any fresh appointment over the existing regular post and also against vacant post without the prior approval of the finance department through the administrative department.
This will apply to municipal boards also.
No, Lordship, Lordship, it is.
This is very, very difficult, sir. Miss Bhattacharya was appearing the matter. She was
Yes,
conversing
Lordship,
with
this municipal board, Lordship, I'm not appearing on behalf of the municipal board, Lordship. Only on behalf of the deputy commissioner, Lordship. Additional deputy commissioner is the party here, Lordship. Respondent 5. Lordship, it is this notification is stated the local bodies is also there. Lordship. Local bodies includes, Lordship.
M. Bhattacharya. There was no appointment, sir. There was a promotion. Keep that back. It was a promotion.
Promotion.
Not a fresh appointment. They were serving in that board. They were given a promotion. They are not being given the pay of that promoted post. M. Bhattacharya. M. Bhattacharya.
And we checked the records, there is no record of his appointment.
Karbi Anglong would say, Karbi Anglong not giving you any appointment letters, will that make all their appointment letters vanish?
Because they are not given any appointment letters. And service, there is a service role which indicates his appointment date is 95, not 90, not 87 as claimed. There are records of his appointment, it's 95.
First case, my lord, it is Harmon Chakraborty. There are 4 petitioners. They were all appointed appointed prior to 93, 1.90.
From where do we say that?
Paragraph 2.
Of the writ petition?
Of the writ.
No. You will have to give us something to show that in 19, you existed in the department.
Well, Karbi Anglong Council and they have to file affidavit. They have not denied. Even the affidavit which has been filed.
They have filed affidavit.
Yes, they have not stated so.
Have you filed your affidavit, Karbi Anglong? And you say that they were not appointed? When? Mr. Gogoi, you are also representing Karbi Anglong?
No, I am for the PH.
Page 23. Where is the original?
Under paragraph 5 of the Karbi Anglong's affidavit, your lordship can be said.
Paragraph
5.
The admit condition.
Petitioner number 1 was initially engaged as masteral worker.
Yes.
Then the
Our instructions are different.
petitioner number 2.
Our instruction, we receive something from the finance, we check our records, our records doesn't reveal anything.
You are for the?
PhD, my lords. State.
This work charge, now tell us one thing, there is something called a transfer subject or something?
Yes, my lord, transfer subject.
So you have an appointment letter when the Karbi Anglong is saying that we have appointed them on oath.
95 of
That's it, my lord. They say so, it is a transfer subject.
Oh, my lords, engaged as MR as 87, but appointed and in 95. Appointment letter comes in 95.
They are working.
How does it work? No. Even that 95 letter, kindly see. Page 22.
Yeah.
Mr. Gogoi.
My lords.
Page 22.
Yes.
Appointment is purely temporary for 3 months.
Page 22. Upgraded.
Upgraded, my lords.
Yes. When can the upgraded? And what about this number, page number 24? Is appointed?
Of this case, Chakraborty's case.
Wait, Uttam Das, sir. 24. Page 24. Uttam,
We are on this. Harmohan.
Page
24.
Uttam Das, sir.
Serial number 2. Page number 24. Appointed. Then page number 26. Upgraded.
Work chart.
Upgraded?
Yes.
So there must have been an appointed.
Appointed and then upgraded. They have stated in their affidavit, paragraph 6, that the petitioner number 2 was initially engaged as masteral worker on 92. Subsequently, the petitioner was temporarily upgraded to the post of work charge employee, Khalasi, in 2001. For a period of 3 months, thereafter he was appointed as a work charge section officer by an order dated 22/5, and they are continuing continuously more than 30 years of service. And regarding the second case, my lord, second case, his appointment letter is fortunately there. His appointment is in the year 1990.
1990.
And he is continuing. Shall be along, he is not denying.
Can we have it on Tuesday or Thursday where we
My
can
lords.
pass the orders?
Thursday.
Today being a motion day with.
No, no, sure.
And
If
also
your
this
lordship
order,
wants, I can give a.
this order also will have to.
No, finance.
This order, my lord, sets aside the open loss judgment, and it says persons who are appointed prior to 93, they are regularization, pension, everything to be paid. But persons after 93, they said you approach somebody, some observation is there that I have not gone carefully.
I had to defend because state finance, we are the department, will bleed the money. Money will go for us, go from us.
You will defend against what?
No,
The transfer subject, my lord.
still then the money goes from us.
No, no.
They-
You will
they-
defend
they
against
must-
what?
Now-
Will appeal number 4514 of 2025? Cannot.
No, my lords.
Their affidavit saying we appointed.
My lords.
Only person to defend is somewhere behind that printer. He'll come up with something.
On
Yes.
Thursday, my lord.
Thursday.
Thursday.
Next
Thursday. No? Next.
Next Thursday would be? No, not next Thursday. We'll have it on 2nd.
2nd June.
2nd June.
2nd June, my lords. Okay.
No, next Thursday মানে মেটে পড়ে নাকি?
2nd June হলে কি ওকে এটাই করতে?
পড়ে 2nd June
It is a Tuesday.
2nd June.
2nd
Tuesday.
June.
হ্যাঁ?
All right.
কোন আছে? No, no, এখানে 2nd of June. 2nd of June, পাঠার। এখন মোক ভিতৰত দিব। দিলে।
My lord, the family pension, my lord, in regard to the petitioner number 1, my lord, the refuse being, my lord, marriage is void. So far, my lord, the son of my lord, the petitioner number 1, that is the petitioner number 2, the daughter, my lord, is in this part share of family pension, they admitted. So my lord, so far the share of family pension to petitioner number 2, it is clear. So far, my lord, the petitioner number 1 is concerned, my lord. It is admitted that, my lord, during the substitution of first marriage, the second marriage was, my lord, solemnized, which is void. As per Hindu law, my lord, is fairly admitted case. But, my lord, from the document, my lord, it can be looked out, my lord, that this wife of the husband of the, my lord, that is the first wife, she got married to another person prior to marriage of the husband of the petitioner. And she was happily living, my lord. But my lord, the husband of the petitioner also contact marriage, that is void.
First the wife ran away, then the petitioner, then the
first wife. First wife. Then the thereafter petitioner and petitioner, my lord, in 2015. And my lord, dissolution of marriage was, my lord, 2016.
Between the first pair.
Prior to dissolution, marriage was, my lord, semi-life. But my lord, my case is regarding to the first, my lord, petitioner, that my lord, long, my lord, living his husband and wife, my lord. And my lord, a son was born in 1998, a daughter was born 2001. My husband died, my lord, only in year of 2022. On that point, my lord, I have relying on one Supreme Court.
No, to 2015, the marriage.
Nice. Registering marriage.
Who died?
Between the petitioner and the.
If I may explain.
No, I'm a little confused.
I'll just.
When did you marry?
My lord, 2015.
And when was the son born?
to 1998. My lord, registered marriage in 2015.
You registered the marriage in 2015?
2015. Marriage
Married long ago.
Marriage was long earlier, 1998 itself.
Now I got it.
Yes.
Yes.
Now, my lord, I am relying on judgment. My lord,
Let him
the
finish.
judgment says, my lord, that, my lord, long living, my lord, as husband and wife, and when a son is born and a wife is born, my lord, it may lord happily can be declared or presumed that they are husband and wife. My lord, I am Manmohan Singh case, my lord. Paragraph 23, 24, and 25. Okay, please. Also Reliance Evidence Act of 114.
Paragraph?
23, 24, and 25. So, my lord, there is no dispute from the document, my lord. It is clear that they are living together, my lord, son and born, daughter born. And earlier wife, my lord, the first wife got married long prior to marriage.
Understood. Yes, sir.
Let's put it this way, Lordship. The petitioner married the first wife in 1990. In 1990. He retired from service in 1994. He retired from service in 1994. And he says that the second lady came somewhere in 1998.
After the?
Post-retirement law.
Post-retirement.
This is post-retirement. And the marriage was later on registered in 2015.
Do we have that certificate?
Yes, it is there. Yes. It is there. That marriage certificate, Lordship, is at
page 26, my lord.
Yes. So this marriage is registered in 2015. And thereafter, the divorce with the first wife in 2016. Which your lordship will find at page 32 and 33.
2015, the registration.
Yes, my lord. On 30th January 2015.
And 2016 is the dissolution of marriage with the first wife.
First marriage.
That was a case file, just a minute, 13(1)(b).
So, my lord, admitting this is void. I am admitting this is void.
No.
On that way, my lord, I have difficult to succeed in the case.
If?
In that way, my lord, in my submission, it is difficult for me. But, my lord, the long living as husband wife, my lord.
Let him finish.
Yes.
Yes.
Now, legally, the first marriage ended in 2016. Now, the difficulty with us is that we have the documents when he was in service.
Yes.
And on the basis of that,
You paid
his retirement benefits have been given.
to the first wife.
No, my lord.
Whatever.
It was given to him.
Was given to him. So, we have his documents which says that the earlier one was the first wife. Now he has expired in 2023. 22, I'm sorry.
And in this interregnum, did he say
Yes.
that I have got a wife
Oh, he
to
did not.
you?
He did not say.
He did not tell you anything.
Now the connection between the authority and him is no longer there because we have got the documents since when he was in service, and the service document says that the respondent number 5 is his wife. So there is no dispute as of now. Now we have come to know that he has divorced his first wife in 2016. And of course, if it is a divorce, then second wife will have a claim. Because it is a divorce.
So
Otherwise,
now that marriage between the first wife, between the petitioner and the husband, the deceased employee remained a void marriage till 2016.
2016.
After 2016 till 2022, that is the date of death. For 6 years, giving recognition to the child born out of the wedlock. The husband, that man continued to stand as a husband to this lady. So what is this consequence? If a retired person marries after his retirement,
that is what,
and then is
that
his
is
wife,
falls for your lordship's
no,
consideration.
then is his wife entitled to the family pension?
That's what I am submitting, lordship. So far as the entitlement of the second wife is concerned, the law is settled in the case of Rameshwari Devi versus State of Bihar. The second wife is not entitled. Children are entitled. Rameshwari Devi versus State of Bihar.
That was a marriage after
No, that was a marriage.
two wives surviving.
Now here, legally we are with one wife.
Now we have one wife.
Legally we are with one wife.
Now I have one wife.
Yes.
Not I, we have one wife before us.
So,
and yes, I also have only one wife, but now we have one wife.
Lordship. So, now post-divorce, there is no marriage between, the marriage does not subsist with the first wife. So post-marriage with the second wife, in my humble submission, would have a claim. But from where do we calculate the pension?
From the death.
From the
date of death of the husband. Of the husband, she's asking for family pension.
Yes.
Which is after he married her.
Yes. So it will be from 2022.
Yes.
And her recognition will be coming from only 2016. 2000. That is what your lordship has.
If that solves the issue for you, for him, for everybody.
I think that is
No, I read somewhere a few this thing ago, the pension rules, I forget which one. But there was a provision for marriage after retirement.
Yes.
There is a provision somewhere.
Provision need not be there, anybody can. So
No, provision for granting pension to a wife who was married after retirement.
It has to be, because now legally the first marriage is terminated. It does not subsist. And if there is a divorce, she must have got her.
We can probably ask you to give the recognition from 2016, the date of divorce of the first wife, because at that point of time there was no question of a family pension. So her family life starts from 16. Officially with you. And after the death, whatever is the entitlement.
Yes. So
because his pension, his DCRG and everything he has already got.
That is
1994.
It will be now only the family pension.
Only the family pension. Why not? We'll come back in 5 minutes. Kindly see if you can trace out the provision in the pension rules. There is a provision.
I will just.
Marriage after retirement, either there is a provision in the rules or in the OM.
Got one judgment, but right now I could not remember my lord. Post my lord retired.
Lordship can take it on Monday. I will raise that.
But do we need that when everything is?
Now, if he marries for the second time, that is a void marriage. And in fact, when he had married that was void.
Hmm.
That was void.
Hmm.
Divorce came later on. So perhaps lordship has to apply mind as to whether now, because the marriage was void, ab initio at the time when it was
Done.
solemnized.
Done.
Post,
Even after a decree of divorce.
even after decree of divorce,
Even
whether
after a
that
decree of divorce.
recognize that it will
I'm
not.
on a different line. Even after a decree of divorce,
Lordship.
nothing stops the same person's marrying again.
Yes.
Even in a void marriage, nothing stops the two persons again marrying in the proper way or something recognized in law. So, given that circumstances, they are living together as per this Supreme Court judgment for a long time, children being recognized in everything. She, if not a legal wife, becomes the lawful wife. If that be so, since at least the daughter is now entitled to the family pension.
Children, we are not disputing.
Is she being granted the family pension? No. Now, there will be no difference in the quantum that you would pay. It
Yes.
would either be in the name of the mother, it would be in the name of the mother or the daughter.
Yes, yes.
Now, the daughter says that is a co-petitioner who says that my mother is entitled. In that scenario, to bring an end to this litigation, in the peculiar facts and circumstances of the case, we will give you the direction that you would, in this particular case, not dispute the marriage or that she is the wife after the divorce with the first wife was declared by the court. Your recognition of her as a wife will, for law, for the purposes of your administration, will be only after the divorce.
2016.
Prior to that, we will record that he is not claiming that he was a legal wife prior to that particular divorce. So that should solve your problem in disbursing the pension to the in the name of the mother, because the only other person who could have objected to it
is the daughter.
Is the daughter. She is a co-petitioner. You are not averse to giving the pension.
No, we are not.
It is only that this should not set a precedent in the department that people would marry and then come and say. That is the only apprehension I can think of.
Lordship.
We'll hold that it's a lawful marriage after. We will not say a legal marriage. We'll say it's a lawful marriage after. The marriage can be recognized in law after the actual divorce with the first wife took place. To meet the circumstances of the case. And therefore, respondents.
Lordship will just add in the peculiar circumstances.
We'll do that. This is peculiar. And the respondent, the respondent for 5 is not.
Somebody is name is shown.
I filed the affidavit also.
But has not appeared.
She is not claiming for.
Nothing, my lord.
She cannot claim.
She is getting affected.
Also,
how can she claim for pensionary benefits now? All she would say is that during the subsistence of our marriage, he was not the wife. I agree with it. But Mr. S. Chauhan, learned counsel appearing for the petitioner, and Mr. Argedi Chaudhary, from a learned senior advocate,
for 1 to 4.
assisted by Ms. L. Devi for the respondent number 1 to 4. Although respondent number 5 was represented in the earlier occasions, none appears today. In view of the fact that there is no specific claim relating to the respondent number 5, this court proceeds to adjudicate the case on the basis of the submissions made at the bar and the records available. The petitioner claims to be the wife of a deceased employee who served in the Air Force as an equipment assistant and who had retired from service on 28/2/1994, full stop. During his service career, the deceased employee had submitted the name of the respondent number 5 as his wife, showing the date of marriage to be 23/5/1990, full stop. During the subsistence of the marriage with the respondent number 5, the petitioner married the deceased employee on 7/6/1999. Full stop. No. When did you marry?
It is 2000.
When did you marry?
My lord, register marriage, my lord.
No, we're asking for your actual date of marriage.
My lord.
Married, the petitioner number 1 married the deceased employee on 6/2/1998. Full stop. It is the case of the petitioner number 1 that that the deceased employee and the petitioner had been living together as husband and wife for all practical purposes, and a son was born to them on 9/12/1998, and a daughter was born to them on 30/8/2001. Stop. This court notices that the daughter of the petitioner and the deceased employee is arrayed as the petitioner number 2 in this writ petition and supports the case of the petitioner number 1. Okay, don't write this. Mr. Chaudhary, if you will have page 5, paragraph 5. Last 2 lines. This lady goes and gets her marriage registered with someone else.
Yes.
That is desertion. So that marriage ended that day itself. The declaration came in 2016.
Yes.
But the marriage
Yes.
finished on 7/6/1999. We did not notice that. Yes.
But then still a few months overlapping. 98 and 99.
The husband of the petitioner, number 1, thereafter expired in the year 2022. Prior to the dissolution, prior to his demise, the petitioner number 1 and the deceased employee had registered their marriage in the office of the marriage officer Sivsagar, Assam, and a certificate bearing certificate number 14 of 2015 was issued on 30/1/2015, registering the marriage between the petitioner number 1 and the deceased. Subsequent thereto, the deceased employee filed a suit under section 13B of the Hindu Marriage Act for a decree for dissolution of marriage between the deceased employee and the respondent number 5. The said decree was granted on 1/12/2016. Full stop. It is the case of the petitioners that the petitioner number 1 had been living with the deceased employee as husband and wife on and from 1998, and therefore the petitioner number 1 and the petitioner number 2, who was born out of the marriage between the petitioner number 1 and the deceased employee, would both be entitled to the grant of family pension on the demise of the deceased employee. Full stop. Mr. Chauhan, learned counsel appearing for the petitioner, has submitted that the respondents have not disputed the entitlement of the petitioner number 2 for the grant of family pension in respect of the deceased employee full stop. He submits that it is an admitted position that the petitioner number 1 got married to the deceased employee during the subsistence of the marriage of the deceased employee with the respondent number 5. Stop. However, keeping in view the fact that the respondent number 5 and that the marriage between the deceased employee and the respondent number 5 had been dissolved by a decree issued by a competent court of law in the year 2016, and in view of the fact that the petitioner number 1 continued to live with the deceased employee as a wife till the date of his demise, there would be no hurdle in law. There would be no impediment in law for the respondent authorities to recognize the status of the petitioner number 1 as the lawful wife of the deceased employee and to grant her a due entitlement of family pension. Full stop. The learned counsel for the petitioner has also referred to the affidavit filed by the respondent number 5, where she has not made any claim to the family pension of the deceased employee and has admitted the fact that she now remains married to to another person. Full stop. The learned Mr. R.K.D. Chaudhary, learned senior counsel, has submitted that in view of the fact that the marriage between the petitioner number 1 and the deceased employee had occasion during the pendency during the subsistence of a legal marriage between the deceased employee and the respondent number 5, the marriage between the petitioner number 1 and the deceased employee would be a void marriage, and the registration of the same in the year 2015 would be of no consequence. Full stop. He has, however, submitted that the entitlement of the petitioner number 2 is not disputed, being the daughter, she being admittedly the daughter of the deceased employee. Full stop. Next paragraph. I have heard the learned counsel for the petition for the parties. Stop. The facts stated in the foregoing paragraphs are not disputed by any of the parties, to the extent that the petitioner number 1 had entered into a conjugal life with the deceased employee during the subsistence of the marriage between the deceased employee and the respondent number 5, and that the said marriage had been dissolved by a decree of a competent court only in the year 2016. It also remains undisputed that the petitioner number 1 had continued her conjugal life even after the decree of divorce between the between the respondent number 5 and the deceased employee, full stop. In the peculiar facts and circumstances of the case, I am of the considered view that even if the marriage between the petitioner number 1 and the deceased employee remained void during the subsistence of the marriage of the deceased employee and the respondent number 5, the cohabitation of the petitioner number 1 with the deceased employee on and after the date of decree of dissolution of marriage, the relationship between the petitioner number 1 and the deceased employee can be recognized to be a lawful marriage, full stop. As pointed out by the learned counsel for the petitioners, the apex court in Madan Mohan Singh and others versus Rajnikant and another, reported in 2010, 9 SCC 209. The apex court has held that if a man and a woman are living under the same roof and cohabiting for a number of years, there will be a presumption under section 114 of the Evidence Act that they live as husband and wife, and the children born to them will not be illegitimate. It is true that such presumption could have been rebutted by leading impeachable evidence, but in the present case, we do not find any such assertion either by the respondent authorities or by the respondent number 5, which may lead this court to deny the petitioner number 1 her claim for a family pension, full stop. We again clarify that it is only in the peculiar facts and circumstances of this case that this court has come to the above conclusion, so that a quietus can be given to the litigation where the issue is one of payment of family pension, full stop. The entitlement of the family pension to the family of the deceased employee is not contested by the respondent authorities, and in fact, they admit that the petitioner number 2 would be entitled to such family pension, full stop. This court has also noticed that the petitioner number 2 has supported the case of the petitioner number 1 insofar as the entitlement of the family pension is concerned, and therefore this court has no hesitation to hold that the petitioner number 1 in the facts and circumstances of this particular case can be said to be entitled to the family pension, which would arise on the death of the erstwhile retired employee of the respondent authorities, full stop. Next paragraph. In the facts and circumstances aforesaid, this writ petition is allowed, directing the respondent authorities to verify the requisite documents which may be required to be submitted by the petitioner number 1 and the petitioner number 2 for payment of family pension in their favor, full stop. After due verification, the respondent authorities would release the family pension and any other benefits arising on the death of the retired employee in favor of the petitioner number 1 by obtaining a declaration from the petitioner number 2 that she would not object if the family pension is released in the name of the petitioner number 1 during her lifetime. Full stop. The petition is accordingly disposed of. তাৰ ওপৰত লিখিব the respondents. Now, since the matter relates to an issue of family pension where the petitioner, where the husband, where the deceased, where the employee, erstwhile employee of the respondents had met his demise nearly 4 years ago, this court expects that the respondents would look into the matter with the required urgency and ensure grant of family pension to the petitioner number 1 during her lifetime, without further delay. The petition disposed of, no order as to costs. Anything more, sir?
Time limit may be there.
Lordship, I also suggest, Lordship, if there is a time limit for him to submit the requisite documents, and thereafter we'll.
Read petition disposed of for the petitioner shall endeavor to submit all relevant documents in consultation with the respondent authorities within a period of 30 days from today, and the respondent authorities would thereafter endeavor to grant the family pension within an outer limit of 3 months from the date of receipt of the documents from the petitioner. From the petitioners. That'll do? 4 months. Read petition disposed of, no costs.
Page 85 is the minute. Page 85 minute.
Have you filed your reply?
Pleadings are complete here. Matter pertains to my lord.
You filed your reply?
Day for yesterday, I have filed the reply.
You filed?
File.
Not on record. Anyway, will it be necessary? Or can we proceed?
You can proceed, but
Let it come for hearing, my lord. Pleadings are complete because it will take some time.
Mr. S. Botagul.
The only thing is whether the issue has been resolved by the finance department with the CAD department, because they are trying to resolve the issue. They are taking responsibility.
Our affidavit is clear.
The indication is let it come up for hearing, because by that time he will have some concrete instructions on whether the matter has been resolved. Yes. Mr. S. Botagul and counsel for the petitioner submits that he has filed the reply as proposed in the order dated 17/2/2026. Full stop. However, the same is not found on record. The learned counsel appearing for the parties are in consensus that the matter can be taken up for hearing since the pleadings are now complete. Full stop. Accordingly, list this matter again on
any day, but
Any hearing day, my lord, subject to my lord's convenience.
July 1st of ekdom immediate reopening or kibara date diok na 21, 24.
On
16th of July 2026.
Can it be on, my lord? 21st of July with all respect.
Why not?
I'm not
21st of July.
I'm so obliged.
But regarding incharge principle, my lord, during my lord pendency of this petition, I have already given the academic charge. Now only financial charge has not been given. So my lord, may I pay that, my lord? Your lordship, kindly, I will file a representation. They will consider my that charge. That is only. Because during the, your lordship, kindly see the last order dated 29/4/2025. Everything written there. 29/4/25.
29/4/25.
Because financial power, my lord, every time I have to go to 40 kilometers mile to the because the financial power is still in the with the IS.
Yes.
So I'll file a representation before the authority, they will consider, my lord. Because
academic, I still, and now I am academic principal, my lord. Only reason they have given that B.Ed, B.Sc and M.A. Both I have got obtained by without permission. That was the case.
Yes, that will do.
Yes, Your Lordship.
Heard Mr. T.J. Mohanty, learned senior counsel, assisted by Mr. M. Islam, learned counsel, appearing for the petitioner. This also heard Ms. H. Terampi, learned counsel, appearing for the respondent.
1 and 2, Your Lordship.
Number 1 and 2. Why not 3?
Or 3 also, Your Lordship.
And 3. What happens to notice on respondent number 3? Was it?
Private respondent is not contested, my lord.
But then when you were handed over that in charge, academic in charge,
My lord.
is there a possibility that he might have approached this court in another writ petition? Some other orders are passed therein. There might be a confusion then. We'll have 2 contradictory orders.
My lord.
If it is convenient for you,
My lord.
we can have it at 2 o'clock.
My lord.
Perhaps Mr. Islam and Ms. Terampi can both make an effort to find out if Mr. Procedural Islam has filed any writ petition challenging the
So far, our
taking away of the
of the
charges.
in charge.
We'll have it at 2.
My lord.
Better to have a concrete information.
My lord.
Just find out from your department.
Yes, Your Lordship.
They would know the school. They would know his writ petition.
Whether my in charge, you are saying
That
like-
order is under challenge. If
Ah.
there is a stay there,
Yes.
if we allowed, if we close this writ petition, you would
Then
be
it will be
problem.
difficult, but I am still
Not
working.
that he would, not that he would be,
Yes, yes.
or
Yes,
maybe
correct.
there is a case pending which would be required to be heard together
My lord.
with
But
Mr. Islam's
in
case.
that case, my lord, I would have a party, but till now I am not getting any.
He may not, because
File.
he will simply challenge the order of the
No, correct.
DSC and then he will not make anybody else a party.
My lord.
Order of the DSC is under challenge. It is only an in charge. You need not be a party, would be his argument.
Maybe.
We do not know. It will create a problem.
My lord. Take it.
Otherwise, at 2, if you can say that, if you can make a statement that there is no other case pending regarding the same in charge thing,
My lord.
then we'll pass the orders. Find out.
Yes, Your
At
Lordship.
2,
Yes.
this case information system will give you by the name.
Otherwise, my lord, that is my plan. Only that.
Otherwise,
Because
we'll
by
simply say that academic in charge has been given.
Given.
Rest of the issues would be, issues would have some disputes. Therefore, you file a representation, let them take
Let them take a dish.
a call.
That is my case.
Yes, Your Lordship.
We'll dispose it of. Yes.
Here the question is very small.
Mm.
Issue is small because one advertisement was, they have filed the affidavit. And my probably my lord, I am not going to file, and lordship is on the affidavit. It has come to light that I am not going to file any reply. Fact of the case that one advertisement was published for selection and appointment to the post of Bengali, Assistant Professor Bengali in GC College, Silchar.
Mm.
The petitioner appeared in the participated in the selection process, and she was, although her name was no select list published, and she was not selected. Now they are stating that since she is sole candidate, she appeared. So fresh advertisement to be issued. Against the fresh advertisement, I approach this honorable tribunal. I will state that advertisement.
You approach the tribunal?
This honorable court.
Acha.
No. This honorable court, sorry, mate. So honorable court has stayed this. And now my lord affidavit is given on the ground that because I am the sole candidate appeared in the, can it be a ground for rejection my selection appointment? That is before your lordship. And
Lordship, as per the instruction and the affidavit, Lordship.
as per the instruction that we have, I filed the affidavit, Lordship. 37 candidates applied for the post.
None appeared.
No, seven, then seven.
Seven appeared. And
Call for interview.
But paragraph 5, Lordship, of my affidavit, but of those only the what no remark, nothing, why they were not present or why absent or what, nothing is there. Only one candidate left out, that is, so some doubt arose in the department. And so, Lordship, their press interview was called for, Lordship. It was directed.
that is your affidavit.
Lordship, page 42, paragraph 5.
And what does the college say? The election committee, what does it say?
She was selected, my lord, only ground taken by them. There's no healthy competition. My lord, I doubt about whether it can be a point.
That there was nothing on record to show what happened to the other candidates.
Yes,
Did they appear or
that
did
is-
they not appear?
That is not there, but then the question is this, there is some aberration that there is some complaint. But in our affidavit, we have stated that we
Where is
received,
that complaint, sir?
no
No,
complaint.
I'm not talking about complaint. Page 42, Lordship. That is nothing,
He said there is an averment about a complaint.
not in our
In
affidavit.
our affidavit, we have said we haven't received any complaint any point of time against
Oh,
her.
that is fine, but just to maintain the sanctity of the selection process, can we be informed as to whether what was the comment on
What
the
happened to
other?
others? Yes, that.
What happened to the others?
Possibly we can furnish that information.
Because what the department would feel is that there is a marks against only one candidate.
Yes.
So you've selected, filled up everything,
Right.
and then you forgot to fill up the others.
It may be a very good appearance.
Huh?
Anyway, my lord, so far that point is concerned, I can take care of.
By when?
Within a week.
Your convenience, you give us a date, we'll. Otherwise, one person appearing, so many persons
Yeah,
willing to
apply-
participate, one
apply.
person coming forward, you not receiving any complaint.
No, regarding
No.
complaint, it is now
And show us the law that if many people are invited and one person comes, you cannot appoint.
7% came, but
You
no,
cannot
in the,
appoint.
in the remark column, what happened to those, nothing is there. So at paragraph 5, we have carried, at page 42,
Page 40?
42, running page.
Page 42 is by the college.
Only
And
then-
you have to read
Called-
by your.
Called for interview. There is no whisper they appeared in the interview.
Not sure, our affidavit, not some pagination may be wrong, Lordship.
Your affidavit
No,
starts
page
according to our records at page 44.
Not sorry, Lordship.
Para 4.
Para 5. Para 5.
Out of the said applicant, 7 candidates called for interview, selection committee. Not that 7 appeared.
Do you have the records
No, Lordship, I don't.
based on which this affidavit is filed?
No, record.
We will
Yes,
require,
based on which I,
no,
no, instruction I'll get. Record.
instruction do you have?
That instruction right now, I don't have, Lordship here.
No, that
But
when you
affidavit-
say that the remark column was blank,
Yes,
you will require that one also.
that one.
That particular
Selection
document
committee.
which was sent by the college to you.
Yes, Lordship, I can.
Hmm?
Yes, Lordship.
And according to the rules, what is required? Your approval,
Approval.
Approval.
only approval.
That part is because.
Only
selected,
approval.
Yes.
So
Committee,
that,
committee has selected and forwarded it.
So
So that doubt arose, therefore, Lordship, that was then.
Lordship
Shipment
can
decide
do
not
one
to-
thing, your Lordship
Yes.
can fix it on 26th. In the meantime, I'll.
both of us,
Yes, that will.
you can get your scan copy at least. Of the
I-
records.
Lordship,
But Mr. S. Nath, learned counsel for the petition. Mr. S. Dr. learned senior counsel assisted by learned counsel for the respondent number 4 has submitted that the affidavit in opposition has been filed by the respondent number 4, which would show that there was no complaint received by the selection committee or the college concerned regarding the selection process taken up for but they were taken up selection process taken up Full stop. The Learned Council has sought for some, Learned Senior Council has sought for an accommodation to produce the records of the selection committee before this court.
Yes,
Full
that
stop. A similar prayer has also been made by Mr. Tohbildar, Learned Council appearing for the Department of Higher Education to produce the records which were received from the selection committee, based on which the affidavit in opposition has been filed. Full stop. List again on 26th of May 2026, allowing the production of the records.
I think scan copy will do.
scan copy.
Anything. Get it, have it attested by someone.
Yes,
Scan.
much of it.
Obliged.
May it please your lordship. This case challenges the appointment of respondent number 4 to the post of financial management officer, junior grade 2. The advert was issued on 9th May 2023. Your lordship will find it at page 23. It required persons with benchmark disability. That rule is at page 25. If I may read, lordship, persons with benchmark disability, physically handicapped persons or persons with disabilities as indicated against various items of vacancy details can apply for respective post even if the post is not reserved for them but has been identified as suitable. However, such candidate will be considered for selection to such post for general standard of merit. Persons suffering from not less than 40% of relevant disability shall alone be eligible for the benefit of reservation, and other relaxations are as permissible under the rules. Reservation and other concession and relaxation as permissible under the rules only when degree of disability is 40% or more and the posts are reserved for physically handicapped person candidates. My lord, by way of a speaking order that was conducted by the Gauhati Medical College, in a TET examination, this respondent number 4's candidature was rejected. That your lordship will get at page 33. 32 is the speaking order.
Okay.
It starts, whereas pursuant with complaints received from various corners and news items published in various newspapers about fake and fabricated PWD certificate, the principal GMCH was requested with this office letter number so-and-so that a medical board be constituted to verify the genuineness of the candidates and the candidates who have applied under PWD category for the post of LP-UP teacher under DEE Assam and were selected in the final select list against advertisement date 18/9/21. In the light of the above notices, conclusion part, lordship, in the light of the above notices, mentioned notices, report of the medical board, approval of government in respect of PWD candidates, the candidature of 270 candidates are shown below at table A, having disability less than 40% is hereby cancelled and rejected from the final select list.
Serial number 109 is the respondent.
Yes, lordship,
Yes.
page 33. Now, at page 20.
Page 20.
For this post, the
He has been-
respondent 4 has been selected.
As a reserve category candidate.
Yes. 99.
This is elementary education? No. Why is this Directorate of Elementary Education doing it? Why is the APSC there?
APSC had conducted that selection.
For the post of 80?
No, Lordship,
No.
page 23.
No, page 23, Assam Public Service Commission does not.
Is 33 is, my lord, in respect of other recruitment, my lord.
That is an respect.
Other
Okay,
recruitment.
okay. He
In that-
appeared in the APSC, he
Yes.
got selected. But when he had appeared in the Director of Elementary Education,
That 30% of
30% was, he
Here,
was not
50%.
30%, he did not even have 30% disability and therefore his case was rejected.
her
But
case
you
is that,
accept
yes,
it-
my lord.
But you accept it as 40%?
No,
Because you did
our,
not send it to me.
on the basis of the certificate, I have filed an affidavit, APSC, that was 50, my lord, 50% certificate was granted. So we are only, my lord, go by the certificate given by the candidate, my lord. We allow him to see.
So,
So now, my lord.
no, you are the APSC.
We are the, I'm
You have published this list.
my lord.
Who is the appointing authority?
Appointing is the government, my lord.
Who is the government? In what department?
Housing and
Urban and housing.
Housing and urban, who appears? Now, are we to understand that the state government has one single policy for physically handicapped or for any other reservation?
My lord.
The government of Assam would have one single policy for everybody? It cannot be department-wise policy.
My lord.
It has to be one policy.
Same
This is
board,
the
my
man I'm
lord,
going to take.
same board. My lord,
This is from
actually,
our experience. I do not know if I can take judicial notice of this.
Yes, my lord.
But we had a tough time defending the rejection of several physically handicapped persons.
Physically handicapped,
because of
always, my
that.
lord, always, my lord.
The Director of Elementary Education, this thing, we had a tough time defending it.
My lord. Yeah, I understand.
Short while ago.
Uh,
So therefore, if the policy of the Director of Higher Elementary Education is that you have to undergo a fresh, if the policy of the Director of Health Services is you have to undergo it afresh,
yes.
this certificate is nothing.
Then, my lord.
Then how could it be done for the AP?
Yes.
How can the appointment be given? You may recommend him.
Yes.
Recommendation is no big deal.
No.
But the appointment part, how can the government have two stands? For APSC people, we'll go by the certificate. For grade 3 assistant teacher, no. You go anywhere here, sir.
Again, no, there is some problem. Suppose hearing disability. So it will be fluctuate, my lord. So that is why only for 1 year it is given. Always certificate is for only 1 year.
We are not on that. If the government takes a stand that it is for certain disabilities, they have to show us the policy.
Yes, yes.
Otherwise, it is
Yes.
one and all. It has to be one for all, for every category. And they have it like this for different. And what was this post?
Financial
Management officer.
Financial management officer.
Yes. Now this financial
management officer, junior grade 2.
Now this here and a teacher's job, almost stable job, inside the same room. So there you send him for a test and here you do. His recommendation we don't mind.
My lord. No, only
Recommendation,
our duty is APSC only, my lord, recommendation. We are certificate given by the candidate, we accept it. And now it is to verify the government, my
I don't mind that, but
my lord. No, so far I am
how
now.
can it be two different policies for two different situations?
My lord, that, my lord. In one department, you are 30%, in one department, you are 50%, my lord, that will be.
No, whatever it be, that certificate given by the PW, that under the PWD Act, that Person with Disabilities Act of 2016, whether it is final.
That is the
That was the issue in that case. What happened?
Yes.
We don't know. Yes, sir. Smiling. Tell us.
He is challenging in division bench. One matter is pending.
But division is sitting.
No, what happened to that matter?
Yes, it's continuing.
No. What we are wanted to know is what, another person. Yes.
My lord.
Lordship, the appeal is still pending, Lordship.
No, appeal, what happened to the writ petition?
Writ petitions, they were all listed in the first week of August.
Writ petition.
My lord, actually.
Writ appeal goes.
Writ
petition.
No. Initially, he has filed writ petitions. Few of them were dismissed. He preferred a writ appeal. Then he withdrew with liberty. Then he preferred review. Review was also dismissed. Then now he has preferred a writ appeal. Writ appeal is pending.
So as of today, the stand is that the second opinion could have been taken.
Yes, Lordship. That
now,
OM of 2000.
Now, how does the government explain why it was not done for the APSC candidates?
APSC candidates.
No, here probably, my lord, so far, my version is there. Here, my lord, Again, he was examined and got found 25%.
Found.
Probably, my lord, he is here.
Have you filed your affidavit, madam?
They have done the re-verification and they
Of
found
what?
that it's 25%.
So did you appear before a board?
Again, re-verification they have done, but the.
Did you appear before any board for the re-verification?
Yes. But they didn't do the proper.
No, that is another issue. You are re-verified and you have been found to be 25%. You require,
They are saying 50%, they are saying 25%.
have you,
Your lordship will kindly see the certificate which is at page 40, my lord. There they say it's 50%, and that has been issued by the medical authority, Gauhati, my lord. And there is a statutory guideline.
Permanent.
They are doing whether that has been done. as
have you been
guideline.
appointed? Have you been appointed?
Not.
I,
He has to send this one.
Any stay order, madam?
Yes, my lord, subject to outcome of the writ.
Huh?
Subject to outcome of the writ.
I am the respondent.
15/7/24.
You have not filed
Order
your
this
affidavit in opposition.
But my lord, see the gazette.
This is the issue. Issue has been framed in this regard, my lord, in DB.
Stability of. And how they have done the assessment, that's it.
Yesterday, it was in the division matter. He has argued, my lord, I have seen.
Actually, they have no power.
Once it is given for permanently, then it can be.
Huh?
Guidelines for assessment, how they are doing the assessment.
So he knew এটা সেভিংস করে পেলে পেলাই থবি ইয়াতে।
Madam, so far as the recommendation by the APSC is concerned, what we understand is they are not the authority to verify any of the documents.
Yes.
They had to assess it on the basis of 30% disability. He gave a certificate that this is my certificate, 50% disability. Meritorious enough to be considered on that category. They have made a recommendation.
But my lord, the authority to issue a disability certificate.
No, we are on that. If you are challenging the candidature itself of that consideration of the candidature, the APSC could not have evaluated all the documents or verified the documents. They would go by whatever is before them.
Yes.
Taking it to be true. It is only at the stage of appointment that the verification has been done, would be done. At this stage, she states that she has undergone a re-verification and they have found her to be below 30% also.
So that's why no appointment made.
So the appointment is not coming as of now. Should we wait for this writ appeal to be considered whether the re-verification for her could have been done or not? If the writ appeal goes to say that it could have been done,
then
her candidature goes. His writ petition would not have anything more to be adjudicated. If that power is set aside and she is held to be 50%, above 50%. In that case, even her rejection by the Director of Elementary Education, that re-verification goes, that rejection will not matter. So I think this writ appeal would decide the fate of this writ petition. Shall we keep it for some other day? After the writ appeal. When is the writ appeal next to be listed?
24th
of July.
July
24th of July.
Yeah.
We'll keep it in
June. But on that date, it will not be because I have given the entire judgment voluminous because the law has been now settled in PIL.
That would decide.
Why should we let them judicate division?
Why should we hear it?
Yes.
We'll do it on the 21st of July. Is a hearing day.
Hello.
Has been submitted before this court that, you write like this, heard Miss B. Chaudhary, 25 3-day attendance, it has been submitted before this court that an issue regarding the authority of the government of Assam to conduct a re-verification of the benchmark disability after a person is equipped with a certificate issued by the Department of Empowerment of Persons with Disabilities, huh? Issued, oh no, issued by, I don't know, sorry. Issued by the competent authority under the PWD Act, Person with Disabilities Act 2016, is under consideration in WA number 37 of 2026. Accordingly, with the consent of the parties, this matter again on the 21st of July for consideration. But Mr. B. Purkastal and counsel appearing for the petitioner. The petitioner alleges that the order dated 28/11/2025 passed in WPC 6649 of 2025 has not been complied with by the respondent within the time frame given by this court. Full stop. The learned counsel submits on instructions that the representation along with the copy of the order had been served upon the respondent authority on
4/12/2025.
Full stop. The learned counsel submits that although a hearing was held on 21/1/2026, till date, the result thereof has not been made known. Full stop. You should notice steps within 3 days, list after 4 weeks.
Well,
This I has been filed, Lordship, to basically dispense the term cost of rupees 25,000, which was passed in order dated 24/4/26 and 14/5/26, my lord. What happened is, my lord, there was a delay of 1 week, my lord. We were supposed to file it on, my lord, 8th, but because of the ensuing elections, my lord, we could not do it at that point of time. And my lord, because of that, my lord, the department could not furnish it, but they have sent us the affidavit, my lord, on the last date itself, on 14/5 itself, the day the case was listed. So we were 7 days short, my lord, of filing the affidavit. We were 1 week short because of the ensuing election, my lord. And my lord, otherwise the department is generally very particular, my lord, and prompt, my lord, in filing, my lord. Unfortunately, my lord, this happened, my lord. Therefore, my lord, I pray that, my lord, this part we will file it, my lord. Today it's already 2 o'clock, my lord. So I will file it by tomorrow is closed. Monday morning we'll file it, early morning, and we'll serve him a copy. Because if we file it today, my lord, again we have to give the cost. So we'll file it on Monday, and we'll give him the thing, my lord, in the main case. We apologize for the delay, my lord. Department.
If Hukon Learned Counsel appearing for the applicant and
sir.
Counsel appearing for the respondent in this interlocutory application oblique petitioner in the repetition by an order dated 24/4/2026. This court had directed that the petitioner, the applicant's hearing would be allowed to file an affidavit on or before the 8th of May 2026, failing which the affidavit would be permitted to be filed only upon payment of rupees 25,000 as cost with registry. The learned counsel appearing for the applicants has submitted that although instructions were received and affidavit was prepared on time, the same could not be filed on or before 8/5/2026 due to some technical difficulties in the office of the counsel appearing for the parties, for the respondents, first of all. The Procon Learned Counsel appearing for the applicants has submitted that the requirement of payment of 25,000 before the registry may be dispensed with. The affidavit may be permitted to be filed, so that in the interest of justice, not so interest of justice. On the submissions made by the, are you objecting to it? No.
After judiciary order, my lord, that after lordship, my lord, I have nothing to say.
The learned counsel appearing for the writ petitioner has submitted that the affidavit will be required appropriate adjudication of the on submissions of learned counsel appearing for second comma. This court allows the file on or before Monday.
Monday.
What is the date of Monday? On or before the 1st of June. No, file on or before the 1st of June 20, comma. It is provided that the registry shall insist upon payment of the cost of rupees 25,000 before the registry prior to filing of the affidavit, full stop. Further orders in the IA would be passed on the next date of listing. We are permitting you, and we hope that this matter goes before that bench who can then withdraw the costs. We are allowing you to file it for the time being. The court which passed that order will have to take a call whether it can be recalled or not. We are not recalling that order. Payment, further orders regarding regarding payment of costs will be considered on the next. You file it by the 1st of June, maybe that court will consider. That's fine.
No,
It 1st of June listing diya nahi man. Nije list hai budget.
But let petitioner be argued today, my lord. Our part may be heard in another day, my lord. Is still
regarding?
Your Lordship, this is regarding regularization of these petitioner services.
Contractual.
They have been, it's not contractuals. They have been serving for the last 25-30 years, Your Lordship. And the law laid down by the...
Under the, under appointment letters?
Yes, Your Lordship, in the various colleges. They have been appointed way back in 92, 95, 97, 2000.
We'll take it up on a hearing day. We are told that Upendas has undergone some modification.
No, the judgment has been delivered yesterday. And this also squarely covered.
Some modification.
Not modification.
Some serious modifications.
Yes. No, the modification is with respect to the work charge employees. Because the work charge employee was not before this honorable court. So this honorable court in the division bench has said that they are also not entitled. The judgment was delivered in the single bench by Justice Ujjal Bhuiya. And that was reversed by the division bench. So while delivering that judgment, they have undertaken the work charge employees also. They were not before this court. Now Supreme Court has said you go back to the before the Honorable High Court and you ventilate your grievances. But the law and the principle as regards the regularization is well settled in Binod Kumar, Jaggo and this judgment yesterday delivered.
We'll take it up on a hearing day because it will require some time.
Yes, Your Lordship, the only thing is that it may not take much time. The only thing is that can it be taken up on Tuesday because many of the person has retired and they are going to retire.
Tuesday,
I'll take hardly 10 minutes, Your Lordship.
Judgment Tuesday.
Your Lordship, the judgments are there. If Your Lordship so desires, I can place the judgment.
We will do it then and there. 2nd of June.
2nd of June.
It is taken on the 2nd of June. For hearing. For hearing. Madam, you were required to file an affidavit by some earlier order.
And the chairman, he is also, that means out of station. Even today also I inquired lordship. He is not in station.
Page 27 to what does it say? They have left it to the court.
Left it to the court, lordship, this is there, but lordship, the reply itself is there in the writ petition itself, lordship. If your lordship may kindly peruse page 34, lordship. After passing of the order, I shall rely on the Assamese version of the board proceedings, lordship. Page 34, lordship. Because when they were with a board resolution, they were their post was upgraded, and regarding the pay and allowances also some sort of that means they wanted to sort it out among themselves, lordship. Then because the everything has to be placed before the earlier the municipal board, lordship, for get it vetted and all these things, lordship. Thereafter, lordship, there was an observation. And if I am coming directly to page 34, because this is a board resolution dated board resolution dated 23/8/2022, lordship. Here I am resolution number 8, lordship, page 34. কাৰ্যালয়ৰ প্ৰাপ্তি নং so and so dated 28/2022 তাৰিখ আবেদনকাৰী শ্ৰী মৃণাল কান্তি দাস, শ্ৰী নিতাই সাহা আৰু মহানন্দ তালুকদাৰৰ বৰপেটা ৰোড পৌৰসভাৰ নিয়মীয়া কৰ্মচাৰী যোৱা 25/9/2013 ইং তাৰিখে তদানীন্তন বোৰ্ডৰ সভা গৃহীত যথাক্ৰমে 8 নং 9 নং আৰু 10 নং প্ৰস্তাৱৰ আধাৰত 1 অক্টোবৰত 2013 তাৰিখে প্ৰযোজ্য হোৱাকৈ তেওঁলোকক সহকাৰী অভিযন্তা, বিজুলী বিভাগৰ পৰ্যবেক্ষক আৰু সুইপাৰ এণ্ড লেবাৰ ছুপাৰভাইজাৰ ৰূপে পদোন্নতি দিয়াৰ সৰ্বসন্মত প্ৰস্তাৱ গ্ৰহণ কৰে। লগতে চৰকাৰৰ পৰা নহা পৰ্যন্ত বৰ্ধিত দৰমহা পৌৰসভাৰ নিজ পুঁজিৰ পৰা বহন কৰাৰ সিদ্ধান্ত লয়। পদোন্নতিৰ দৰমহা বৰ্তমানলৈকে আদায় নোপোৱাত তেওঁলোকে পদোন্নতিৰ দেয়ক আদায় পোৱাৰ বাবে আবেদন কৰিছে। সভাই নিয়মভাৱে বিষয়টো আলোচনা কৰে। বিশদভাৱে বিষয়টো আলোচনা কৰে। উক্ত পদোন্নতি দেয়ক আদায়ৰ সন্দৰ্ভত বিত্ত দায়প্ৰাপ্ত তদানীন্তন অতিৰিক্ত উপায়ুক্ত মহোদয়ে ষ্টাফিং পেটাৰ্ণ নোহোৱা পৰ্যন্ত পদোন্নতি দৰমহা আদায় নিদিয়াৰ সিদ্ধান্ত লয়। আজিৰ সভাই অতিৰিক্ত উপায়ুক্ত মহোদয়ৰ সিদ্ধান্ত বহাল আৰু সৰ্বসন্মত সিদ্ধান্ত গ্ৰহণ কৰে। So, because they are dependent upon the government, lordship, and the ADC in the finance department, Deputy Commissioner Office, they have stated, no, you cannot go ahead.
Who is the deputy commissioner in the board? What is his status?
Here, he is also a respondent, lordship.
No, in the board.
Board, lordship, district commissioner is always in the overall charge.
That ADC.
ADC, he is in the finance. He was looking. No, here it is written. During that time, lordship, there are some
commissioner, everybody is a ward commissioner.
Lordship, during that time, lordship, the financial power of the board was curtailed. During that time, when the resolution was adopted.
In 2022?
No, in 2013. 2013, then these things. So thereafter, for a very long time, lordship, the board was continuously like this. All the financial powers were handled by the district commissioner, lordship. So some ADC was kept in charge, who was looking after all the finances.
Who is the deputy who is paying for the deputy commissioner?
Lordship, the government, that means the state council, they will appear.
If we take your stand,
lordship,
correct.
Lordship.
23/10/2013 was also marked with the deputy commissioner.
Lordship.
For all these years, they have not raised any such resolution. No resolution has been No decision of the deputy commissioner has been put before us to say
Lordship.
promotion should not be granted, they will not be entitled to pay. Why are you doing this? Why are you doing that? Nothing. Now in 2022,
22, Lordship.
one ADC who is not present in this board meeting,
Lordship.
he's not there in the board meeting.
Lordship, that's why actually I wanted to see the record. Because this is a quite a old one. I already have communicated that from the Barpeta Road, Lordship, because this is also required to be perused by your Lordship. What actually they have done, Lordship.
This order at page 26, initially, we were given to understand, or we somehow wrongfully understood, that this was an order passed by the chairman without the authority of the board. Nothing can be done. This is a bad order.
No.
Today we see at page 34,
Lordship.
Sarbhasommoto.
So, Sarbhasommoto. Yes, Lordship.
So
because
the chairman was authorized by the resolution of the board.
Yes, without resolution, he cannot do anything, Lordship.
Deputy Commissioner from the year 2013 to 22 does not take a call on the matter. He does not say it is wrong. He does not say it is right. He does not say pay him, don't pay him, nothing. Once these people come to this court, then the resolution is taken in the board that one ADC has said, don't pay.
No, before that, Lordship, and that's why they have come before this court.
We are not deciding it today, but are we understanding correctly? This is the
Lordship.
course of events. This is what has given.
Course of events.
Can it be?
And I also just for your Lordship appraisal also, because the board is the chairman cannot do himself anything. He always have to depend upon the resolution of the board. Without proper resolution, no order can be carried out. So order has to be that means signed by him, but he also has to be empowered through the resolution.
It was.
Yes, but since 2013, Lordship, there are also chain of events. There were ups and downs because yes, Lordship, I think these also, there are many other cases, Lordship, when the chairman was out from the post, someone has, there was interim measures and all these things. So accordingly, Lordship, I think these things were not properly implemented or something, this was, that means it went out of their, these things, Lordship. And accordingly, when they prayed, Lordship, that's why there was a resolution. On their prayer, they prayed before the board, Lordship, for implementation of this and also payment of their arrears salaries. And then, Lordship, this is abedonkari. Karjalaya Prapti Nong Soyensu. There was a joint petition by this Lordship. So on this, it was discussed before the board, Lordship.
Till when was the financial power given to the ADC?
In 2013 itself.
Till when?
Till, Lordship, that also, that these things I am not yet, that means I am not yet updated on these things, Lordship.
But Mr. MP Sharma,
It's at page, it's at order dated 18/9/2025, that restoration of the financial powers. 18/9/2025, Lordship will kindly peruse that. 18/9/2025, in this case only, Lordship. The second paragraph, Lordship.
It stands restored is we understand when.
Lordship, this, that's Lordship.
When was it restored is what we had asked.
Lordship.
Restoration
I think, Lordship, there is an order of this court itself, Lordship, by which it was restored.
Bring it to us.
No.
Bring it.
There was.
Heard Mr. MP Sharma and the counsel appearing for the petitioner. Also heard Ms. M. Bhattacharya and additional senior government advocate appearing for the respondent number 3 and 4. None appears for the respondent number 1 and 2. There are already observations in earlier orders of this court that the state government has not filed their response, although they have been arrayed as respondents in this petition. On an earlier occasion, Ms. U. Sharma Learned government advocate had appeared for the respondent number 1 to 5. However, none appears for the respondents today. The issue in this matter is regarding the payment of appropriate pay to the petitioners, who were promoted to the post of
Assistant engineer.
who were promoted to the post of assistant engineer in the municipal board, Borpeta Road, by an order dated 23/10/2013. Full stop. The records as available in the file indicate that pursuant to an unanimous resolution adopted by the board, the petitioners had been afforded their promotion. The records also reveal that it was a unanimous decision that till that time the financial assistance arrives from the government,
Lordship.
the board would take up the burden of payment of the increased salary to the petitioners. The respondents have filed an affidavit in which the resolution of the board taken on 23rd of August 2022 has been annexed, and in the said resolution it appears that by the resolution number 8, the board had again resolved that the increased payment to the petitioners would not be granted till the time the staffing pattern is finalized. Full stop. This resolution was taken on the advice of the additional district commissioner. Full stop. This court notices that the promotion of the petitioner was done after a unanimous decision by the board, and they had also been afforded the pay scale of the assistant engineer. A copy of this order was marked to the Deputy Commissioner, Borpeta. Stop. 9 years thereafter, the board unanimously decided to follow the advice of an additional Deputy Commissioner, who was not even present in the meeting held on 23/8/2022. Full stop. An earlier order of this court records that the financial powers had been restored on the Borpeta Municipal Board, however, the date of restoration of such powers is not brought to the notice of this court. On earlier occasions, Ms. Bhattacharya was required to file an affidavit bringing on record the present board resolution taken on 27/2/2026. Full stop. Although a copy of the resolution has been made available, the affidavit has not been filed, which is explained by Ms. Bhattacharya that the chairman of the board was unavailable for some time and therefore the not be attested. Allowing Ms. Bhattacharya the opportunity to file the affidavit to bring on record the resolution of the board taken on 27/2/2026, list this matter again on 23rd of June 2026. 24th of June 2026. Stop. The learned counsel for the petitioner shall be at liberty place before this court any material to show the date on which the financial powers had been restored upon the board. Full stop. The absence of any response from the state of Assam, that is for the respondent number 1, 2, and 5, is apparently delaying adjudication of this matter. Full stop. In view of the above, it is brought to the notice of the respondent number 1, 2, and 5 that in the event of absence of response from their end being available on record on the next date fixed, the respondent number 2 and the respondent number 5 may be directed,
Yeah.
may be required to be present before this court personally to answer as to why the state respondents have failed to respond to the repetition, though notices were received and the respondents were represented by counsels on earlier dates.
May I please, Lord sir, I'm appearing for respondent 1, 2, and 5.
Make the submission on the next date fixed. You were here when we were passing the order, when we started the order. You sit there until the time we say that we will have the persons here personally. Next,
Lordship, 21st of June, 24th of June.
24, it's a Wednesday, I believe. 24th.
Lordship, deeply obliged, Lordship.
Kitab, till now, I haven't getting anything. So Lordship, kindly give you one rider that if any verb rider, let me look into the respondent.
We will say that since you have been given the academic in charge,
Hmm.
your grievances for the present would be redressed if you are allowed to make a representation to the appropriate authority for handing over the charge of the financial powers also, and they would dispose it of within a period of 3 weeks. In case any further grievance remains, you will be at liberty to approach this court.
Correct. That's
But Mr. T.J. Mohanto, learned counsel, appearing for the learned senior counsel, assisted by Mr. N. Islam, learned counsel for the petitioner. The Miss H. Terangpi. There is no other.
No, Lordship,
other.
no.
Also, Miss H. Terangpi, learned counsel, appearing for learned standing counsel education, appearing for the respondent number 1, 2, 3. Stop. Anybody appeared earlier for the other respondent?
No.
The notice on the respondent number 4 was taken to be completed by the order dated 21/11/2024, passed by the Law Zima Court, full stop. None appears for the respondent number 4 today, full stop. The grievance raised in this writ petition was in connection with the order dated 31/2024, whereby the respondent number 4 was allowed to act as the academic in charge of what? Of
Borkhanda People's Academy, Higher Secondary School.
Full stop. The case of the petitioner was that the petitioner is senior to the respondent number 4, and therefore it was he who should have been allowed to hold the academic in charge, full stop. A grievance was also raised against the order dated 31/1/2024, whereby the respondent number 3 was allowed to hold the charge of the principal of the school along with financial powers. Full stop. The petitioner had prayed that he may be allowed to act as the principal in charge for all practical purposes, including the academic in charge and academic in charge with financial powers also, full stop. During the pendency of this writ petition, the respondents have passed orders allowing the petitioner to hold the in charge of the charge of the principal of the school, however, only to the extent of being an academic in charge with no financial powers, full stop. On a specific query raised to the council appearing for the parties, this court has been informed that said order dated
29/4/2025. 29/4/2025.
Where is that order, sir?
Page 46.
29/4/2025, whereby the petitioner had been allowed to hold the hold the charge of the academic affairs of the school, no repetition. It has been submitted that there is no repetition in the knowledge of the councils against the aforesaid order, full stop. In such circumstances, the learned senior counsel, Mr. T.J. Mohanta, has submitted that the grievance of the petitioner would be redressed for the present if he is allowed to continue to hold the charge of hold the academic charge of the school, granting him liberty to file an appropriate representation to the appropriate authority to be also vested with the financial power with regard to the school, full stop. The learned counsel for the state respondents has submitted that in the event such an representation has been filed, the same can be considered by the competent authority and can be disposed of within a specified period of time. Full stop. Since the parties are at consensus, this court disposes of this writ petition by directing that the academic charge, that the responsibility of an academic in charge being vested on the petitioner shall not be withdrawn by the respondents without prior notice to the petitioner. Full stop. It is further provided that the petitioner would be at liberty to file a representation before the Director of Secondary Education, requesting that the financial powers also be vested in him till the time he continues as an academic in charge. Full stop. On receipt of the said representation, the Director of Secondary Education shall dispose of the same in accordance with law within a period of 4 weeks thereafter. Full stop. The petitioner shall be at liberty to raise his grievance against any orders rejecting his representation before the appropriate forum of law. Full stop. The petition is disposed of. No order is to post.
Also, as per the last order, the departmental authorities were supposed to produce an instruction, Lordship.
Even without that, we may proceed, my lordship, so permits me.
Probably is here, Lordship.
May I place my case?
Lordship, here, Lordship, I have received an instruction from the Register Dibrugarh University this morning. It's from the that Lordship, it says that MSc in Geographical Information Science is widely regarded as an allied discipline to geography. It is typically classified as a. He wants to.
No, I said unless I place my case, he would.
No, he's. We just wanted to hear what he was saying because I think it will help your case.
I know.
Because he's saying that it is an allied subject.
Yes, Lordship.
If it is so,
if it
I think you may have your relief. Is that your case that your qualification was not considered to be?
I say, in all fairness, you want someone in geography and you want in relevant subject. To say that the other subject may be a part of this subject, geography, and taught. In geography, I just get a geography and geographic information science. Geographic information science is a part of geography. I'll go to that extent. It's taught in geography. As like in our college days, which we had studied, something may be a part of the major course. It's a part of that. Now, I am a candidate who has the qualifications in the relevant subject, geography. And the authorities would like to understand that the other subject would also be a relevant subject, since it is taught of them. So their thinking cannot be brushed aside, saying that there's then some illegality. Now, how do I approach this issue? That's all. We have given a reference to a list of book, particular book, if I may rely on that. My lord would have paragraph 21 of that. May I read for a moment? If it
May I read 21? His lordship there. Now here it's MCA and mathematics. May I read? As is evident from the advertisement, applications were invited for filling up various posts in different subjects, including the post of lecturer in MCA. The advertisement requires postgraduate degree in the relevant subject. The relevant subject would, therefore, in the context of appointment to the post of lecturer, mean postgraduate degree in MCA. In our opinion, for appointment to the post of lecturer, master degree in mathematics is not the relevant subject. The advertisement requires master degree in relevant subject and not the appropriate subject. In the present case, the board of appointment has not stated that postgraduate degree in mathematics is a relevant subject for MCA, but in sum and substance, it is equivalent to a postgraduate degree in MCA for the reason that mathematics is one of the subjects taught in MCA. That's exactly my case. Geographic information science is taught in geography. The Honorable Apex Court says no. The relevant subject would be geography. This
So he cannot have a master's in
allied or other subject, although taught here. That's what
that's a separate subject. According to you, that is a totally separate
No.
subject.
I say
Here, MC and mathematics are totally different subjects.
But still, mathematics is taught in MCA.
But in his case,
may I read, my lord?
no.
For a moment, may I read this line?
You take your seat.
Can I hold your time? May I just read that line? In the present case, the board of appointment has not stated that postgraduate degree in mathematics is the relevant subject for MCA, but in sum and substance, it is equivalent to a postgraduate degree in MCA. Now, for the reason that mathematics is one of the subjects taught in MCA, I am on that. Geographic information science is one of the subjects taught in geography. That's all, and no further. Rest my case, my lord. The relevant subject is geography, MCA. Mathematics taught in MCA, geographic information science taught in geography. No one has the power to expand that. Relevant subject, that's what the Apex Court said. And in 23, it winds up.
And he has a master's in?
Geographic information science.
Not in geography.
Not in geography. Now, may I read 23?
Now,
I'll satisfy a level more. A level more.
Please.
The language of the advertisement is clear and explicit and does not admit any ambiguity. And hence, it has to be given effect to. Since the appellant Ganpat did not have a master degree in computer applications, in our opinion, he was not entitled to be considered for appointment as a lecturer in MCA. We are aghast to see that when a candidate possessing master's and degree in MCA is available, the board of appointment has chosen an unqualified and
You got a master's in geography.
Geography, available. That's my case. And now he says an allied subject. I rest my case.
No, Lordship, the instruction is that, Lordship. There is one more instruction, Lordship, which is provided.
Have you really paid attention to what Mr.
Yes,
Bhanik
Lordship.
has said?
Since a
Paid real attention.
Yes, Lordship. Since there is an available candidate in geography.
No. Go on.
And it's a part of. Specialized price with the geography.
And these are best left to masters, to experts, or
No. We are on a very small issue that both the candidates have masters in subjects, geography and geographic information science. I am not shying away from the fact that geographic information science, although a different thing altogether, it's in mapping, etc., it's done, but it's taught in geography. Identical, I did my research to get a point on that. Number one, if it's taught, then also the advertisement requires a relevant subject, you have to go by that. Number two, it renders the person ineligible. Number three, when I am there. There is no laxity given. So the interpretation is academic. The law is laid. I leave it to your lordship.
Yes, sir. You were saying?
Lordship, it has also stated that the eligibility for appointment as assistant professor in geography is granted to a candidate holding a master's degree in geographical information science. So, Lordship, since he has
that is the practice, we have to find out whether it is correct.
It is
that
taught
is the
in
practice.
Yes, it is a.
That is how they have understood. That
Yes,
is
Lord.
how you understood. That is how 5 minutes ago we had understood. But with the Supreme Court, the word correctly now has to come in, understood correctly. You say that appointment was correct.
Yes, Lordship. And it's a part of geography.
It's a part of geography.
Yes, Lordship. Within the
That
borders.
is why I
of
asked you,
geography.
did you hear his argument
Yes, Lordship.
properly? He said if it is a part,
Part of.
then it will not do. You are making a statement, it is a part of it.
Yes, it is my instruction, Lordship.
In any case, you just need a candidate to
Yes,
teach
Lordship.
the students. You are not interested in this man or that.
No, no, Lordship.
So there is a man who is interested in not losing his job. Let him take the dais.
Yes, Lordship.
In that case, your lordship, the petitioner has not made any argument on how exactly the masters in geoinformatics science is not a part of geography. Or
Answered. It is a part.
lordship, it is part,
answered.
lordship. So other than that, lordship, nothing exists, lordship. Because till date, they have not been able to prove that how exactly it is not a part of geography. It is a part of geography, lordship. We are both SC candidates, your lordship. The advert post was reserved for one SC post.
Have you gone through this judgment?
I have not received a copy.
Have you? Did you hear him reading it out?
From what I could gather, your lordship, then part of MCA, maths is a part of MCA.
So maths being a part of MCA, if it is taught
Lordship.
along with MCA as a part of MCA, even then it would not satisfy the requirements of the advertisement.
So lordship, what about
Now you're having a master's degree
in geoinformatics?
Geoinformatics
science.
Informatics science itself shows that it is also a different subject, which may be at times be taught as a part of, would you say, geography?
Lordship. So lordship, at this stage, what I propose, lordship, let them bring this on affidavit to lordship. Let us also bring it, get out, do our research on this particular part with respect to lordship.
On
Because
this
till date,
judgment?
lordship, on this respect to lordship, whether part or
Had
not
your
a
time.
part.
You had your time.
No, we did not have the instruction till date, your lordship.
But I'm on law.
We had it today. We had it today, your lordship. We got it right now.
It's a part.
No, when the subject
They have
expert has
supported
decided.
your case.
Lordship, when the subject expert has.
They have supported your
lordship.
That yes, it is a part.
It is a part, lordship. When the
that was your
subject
case.
expert, lordship.
Your case, you research, you tell us.
Lordship.
Why do you need that instruction?
So lordship on Monday, then lordship.
Day.
We'll come back on Monday.
Day.
Part Monday.
Part Monday.
Monday.
Obliged.
Part Monday.
Lordship.
This was item number
25, lordship.
What Mr. S. Learned Council is paying for. Let us just formulate out the. It's Monday.
Section.
Third part. List again on 1st of June 2026.
Great from you. Obliged.
Lordship is keeping it as part heard, your lordship.
Monday no hoinki.
Part heard.
Etu Monday kiman pabe? Mr. Bonik, some miscalculation in my.
Lordship.
It will be on 25th of May, not 1st of June.
Lordship.
Okay.
Monday.
Lordship.
25th of May.
Lordship.
Lordship, this matter may kindly be passed over for the day, Lordship.
For the day.
But there is some urgency on my part, my lord. What has happened is that there was an advertisement issued. Although there is no interim order as such, my lord, the appointments have been made subject to the outcome. We have not filled up the posts. There is some urgency on our part.
Another date may be fixed, Lordship.
Because otherwise the pleadings are complete, my lord, it is ready. So
On
far as
what
my
grounds-
case is.
on what grounds have you challenged?
Lordship, the certificate we were issued, Lordship, those were given an another name, Lordship, which was not correct. Later on, these things are dealt, Lordship. The matter was heard earlier also, Lordship. But today, Lordship, some personal inconvenience on my senior, Lordship. The matter may be heard on another date, Lordship.
Who's the senior?
F. Khan, Lordship.
Tuesday?
Similar pair, Lordship, in item number 27.
Tuesday?
27, Lordship, I'm appearing for respondent number 1 and 2.
Please give it to on a piece of paper.
I need 2 weeks time to file our objection. Affidavit in opposition, Lordship.
You are who?
Respondent number 1 and 2. SC BRPL.
Huh?
SC Bongaigaon Refinery.
Bongaigaon Refinery. You are appearing for.
I am appearing for the Indian Oil Corporation Gauhati Refinery.
So these are two different selection
Two
processes.
different selection process, but the issue is the same, my lord.
Advertisement is the same.
What has happened is, my lord, the certificate required some competency certificate to be issued by the boiler authorities. Now, what they had done their training in boiler, my lord, no difficulty in that, my lord. But firstly, that certificate was not there, and in their certificates, the degree was written as BSc. On that ground, because in our case, it was rejected on the ground that that competency is not there. It is required under 24 subsection 2 of the boiler rules. That was not there. And another ground taken by me, my lord, is that on the last date of acquiring the qualification, they did not have the qualification. The certificate is of 9th of August, whereas the last date was 31st of July. That is another.
What is the other case was filed when? Item number 27.
Recently, Lordship.
No, it is 2025, madam. It is 2025.
Yes.
You are for respondent number 2.
Then 2.
1 and 2.
Today is 22nd, my lord.
You have been appearing from 482025.
Yes.
And you are saying recently.
No, Lordship, actually, I have not received the copy. They have
When did you give the copy?
on last occasion, they have served the copy, Lordship. Fine. They filed amendment petition also, Lordship. Amended Korisatu.
Amendment to the cost title.
Yes, Lordship.
He is asking for 2 weeks. If the matters are to be taken up together, even if we take it up on Tuesday or next week, will it help?
Let it be on the 2nd of June, my lord, if it is not inconvenient. I mean, sorry, my lord, 4th of June.
4th of June? You have to give your attendance in writing. But Mr. Swansula and counsel appearing for the petitioners who have prayed for an accommodation for the day. Full stop. Mr. N. Deka, learned senior counsel appearing with the assistance of
M. Gogoi.
M. Gogoi has expressed urgency in the matter. Ms. Deka, learned counsel appearing for the respondent number 1 and 2 in WPC number 624 of 2025 has sought for an accommodation to file her response, comma, stating that the copies of the writ petition had been recently served upon her and therefore the have you received the instructions? No.
No, Lordship.
And the instructions are yet awaited, full stop. Since the matter relates to the selection and appointment, and Mr. Dekal and his senior counsel has expressed urgency on the ground that the appointments have been kept in abeyance by the respondents due to the pendency of this litigation, comma. Please this matters again on the 4th of June, full stop. It is expected that the pleadings would be completed in the meantime so that the matter can be taken up for consideration on the next date fixed.
May I please, my lord? In this matter, I'm appearing to respondent number 3.
Appearance all on paper. You want appearance to be recorded, it has to be on a piece of paper boldly written.
No, I will put it in the paper, my lord. I will put it in the paper.
Not in the newspaper, a short piece of paper.
Deeply obliged, my lord.
No? 29?
Lordship, as per last order, I have filed an affidavit as Lordship directed.
She praying for the subsistence allowance or what? Or area salary?
Subsistence allowance, Your Lordship.
Subsistence allowance not released to you?
Yes, Your Lordship. Period of 21-22, Your Lordship.
How long did you remain under suspension?
Nearly 6 months, Your Lordship.
No, you are asking for area salary, madam.
During that period, Your Lordship.
The area salary for that
Lordship,
period.
during that
Subsistence you had got.
On Lordship.
Yes, madam. How is it regularized? What happened to the subsistence? What happened to the suspension?
He is reinstated in service.
Where is that order?
Lordship.
Lordship, and now Lordship has to
31.
decide on this Lordship first. Then it will again have to be passed.
Tell us. How was he?
Page 31 is the reinstatement order.
Now in exercise of power so and so, order the DP draw against so and so is withdrawn.
Lawsuit.
Oh, nothing remains. Full salary.
No, Lordship, the order actually which was passed and was put
Lordship.
before your lordship.
Lordship will kindly peruse page 32, Your Lordship. Non-royal certificate is also there.
Yeah, Heather.
Yes, it shows the law that when the
Lordship,
DP
I'm
is
just because
withdrawn,
Lordship.
entitled to full salary for the period under suspension.
Lordship, my only prayer is as per the non-royal certificate, Your Lordship.
Yes, madam.
Lordship, this one actually on after seeing this Lordship filed the affidavit. So this order has to be modified, Lordship. Then the proposal,
Which order by whom?
the district commissioner, which led to passing of the order.
Why is it to
publication.
be withdrawn? Does it require to be withdrawn?
Lordship, it was stated that upon direction of this honorable court, where is no such.
Hmm.
Order dated 28/1/2026. Lordship passed the order.
28, what did this court say?
No, not this one, Lordship. There is another order.
Okay, latest order is 27.
We never indicated such a thing.
Yes, Lordship, but we filed the affidavit why these things has been. This was not indicated, but the revenue Lordship, can it be passed over for the time being? J handing, he is on legs, Lordship. Because the proposal has to be
Little
from
research
there.
from your end.
Lordship.
Just tell us by which decision we can say that when a disciplinary proceeding is withdrawn without imposing any penalty upon you on the basis of an inquiry report, how is the period of suspension to be treated? That is when you would be doing the job of a lawyer and not a representative of the petitioner. What was that? After some time.
That's it. I will do it.
অসমৰ এফআইআৰখন দিবচোন অসমৰ এফআইআৰখন দিয়ক অসমত এপ্লিকেবলখন চেন্ট্ৰেলখন নহয় এখন চেন্ট্ৰেল আৰু এখন আছে চাবচোন yes
Lord, I was supposed to file my affidavit in this matter. The affidavit is ready, but some annexures are lacking, my lord. I had also spoken to my senior counterpart who was appearing in this matter, Mr. Dikya Chaudhary, and I've also spoken with the authorities in the BVFCL in this matter. We have probably unofficially arrived at a consensus that if the matter can be sent for mediation, my lord, something positive is definitely going to come out, my lord. So both of us are praying that can it be sent for mediation, my lord?
they say this court directed 50% of the back wages.
Whatever retirement benefits you were supposed to get, we have already calculated and given
Arrear
it.
part,
That also we have sanctioned. The thing is with regard to calculation, and what has happened, my lord, the person was probably terminated from service in 2007 or 8, something like that, my lord. Thereafter, my lord, the EPS account, the employees pension account, it was terminated, my lord. Thereafter, there is no contribution. After that, when he was reinstated, my lord, since the account was closed, we could not deposit money. Now we have already prayed to the authorities to give us the access. Now, what I'm praying for, my lord, if it could be sent for mediation, my lord, they are also agreeable, my lord. Agreeable.
Mr. Your name is?
S. Ahmed on behalf of PK.
S. Ahmed, paying for the petitioner. And Mr. B. Sharma, learned counsel, appearing for the respondent authorities, have submitted that the matter may be referred to mediation. since none of the parties are averse to attempt a conciliation, first of accordingly, I'll give you the part of mediation order. No? There is one third part. Give you the- Appear before, according the parties are required to appear before the mediation center on your convenience.
After 2 weeks, ma'am.
Mediation center on 8th of June
So, true. Yes.
at 11 a.m. A mediation center at Gauhati
Lord.
on the 8th of June.
Not true.
Obliged.
Yes, sir.
Wherein there are two prayers. One is gratuity and leave salary, and another is arrear salary under 6th pay revision. Lordship, gratuity and leave salary has already been paid. And now I'm pressing the arrear salary under 6th.
My lord, by order dated 22/4, you are supposed to bring instruction. Last order, my lord.
Gratuity and leave salary, that is paid. I have received.
What is the amount of gratuity and leave salary together? How much is the amount?
Lordship, 7 lakhs.
This amount is what, sir? This amount is what amount?
7,99,000.
It comprises of what? Is it leave salary?
Leave
Is it-
salary plus encashment, leave encashment.
Gratuity and leave engagement.
Gratuity and leave
Okay. What are you doing about his arrear salary now? He has his instruction paid. He has received. What about the arrear salary now?
My lord, this APDCL has been closed.
APDCL has been closed.
Yes, my lord, by cabinet decision.
Assam
So-
Plantation Crops Development Corporation
Yes,
Limited
my
is closed.
Closed.
Okay.
So,
So
my
what
lord-
happens to the persons to whom they owe money?
So, my lord, that definite amounts were allotted to them after closure. So that is the my lord.
Petitioner retired on subordination on 30/11/2014. And
APDCL was closed when?
last year.
Last year on 25, with effect from.
When did you give the check? In 2026.
Yes, my lord.
Who gave the check?
My lord, managing director. of-
But it is closed.
Yes, my lord.
How do they have a managing director on a closed organization?
No, my lord, it was closed by following a cabinet decision of Assam government.
Decision was taken
Where,
for.
Because it
who
was
signed the check for 7 lakhs?
7 lesson, my lord, this is acting MD, my lord. I'm acting. Because the process was not complete yet, process of closure is
Now
not
the
complete.
process of closure is complete,
Now about to complete,
but not completed.
it's not complete.
What is the arrear salary required to be paid to him?
My lord, that amount is fixed, my lord, this one.
So that amount, who is going to pay?
Now, this is granted by the government of Assam, my lord.
Have you sent the bills to the government of Assam for payment of the arrear salary?
Yes, my lord, that proposal was sent to the government of Assam.
Who
That-
represents the government of Assam in this case? None.
Soil Conservation Department, my lord.
Who?
Respondent 1, 3, 4, and 5, my lord.
Standing Council Soil Conservation. After some time, get the standing.
Yes,
council.
my lord, I am just standing.
My friend is standing.
Then tell us, why are you not paying him? You have the proposal with you, arrear salary, why are you not paying him?
My lord, here at page 18, his amount is written, my lord.
So
Payable limit.
are you saying that he is entitled to the amount?
Yes, my lord, at page 18.
He is entitled to the amount?
Yes,
Yes or no? Yes.
Yes, my lord.
So why are you not paying him?
No, this amount paid, my lord.
And
7 lakh.
page 18, Lordship, gratuity and leave engagement. Page 20 is the Lordship arrear salary. at serial number 4D.
My lord, they are claiming according to six and seven pay, but they are not entitled.
Why?
Because the corporation was sick corporation, it was because of sickness it was closed. So they are not
Not
entitled.
entitled.
Not
If-
entitled.
If a corporation is sick, they will not be entitled to.
Yes, my lord, because board of directors not granted that tier 6 pay salary. Because it depends on the board of director, not government of Assam, my lord.
Who gave this?
My lord, important
Page
judgment.
20, page 20. Who issued page 20?
Page 20,
In extra 5?
Lordship, this bill was prepared by the managing director of the petitioners corporation itself.
What is that important judgment show us?
My lord,
He has some important judgment.
this was the my lord. Second para.
Have you gone through this?
No, Lordship.
Read your turn. But the learned counsel appearing for the petitioner also heard Mr. Hazarika, learned standing counsel, Soil Conservation Department. Full stop. The learned counsel for the petitioner has submitted that the petitioner has received the check bearing number 636896 dated 20th-3-2026 and by the aforesaid check the liability of the Assam Plantation Crops Development Corporation Limited insofar as the gratuity and the leave encashment of the petitioner is concerned has been discharged. The learned counsel for the petitioner has submitted that now the arrear salary of the petitioner remains to be paid. Full stop. Learned counsel, standing counsel has relied upon a judgment and order relied upon the judgment of the apex court passed in
2023, 5 HCC.
name. Give us that.
A.K. Bindal and another versus Union of India.
A.K. Bindal and another versus Union of India and others
2003, 5,
reported in
2003, 5 Supreme Court cases, 163.
to state that the state would not be under any liability to pay the arrears salary. Full stop. The learned counsel for the petitioner has sought for an accommodation to address this court the aforesaid stand of the respondents list. Again, on when do you want it? Yes, you have to address us. Tell us.
Lordship. Second week of June. Second week of June.
14th of
Any day.
17th? 17th of June?
Lordship.
Yes.
Full stop.
All I say.
Yes, madam.
Your Lordship, in this matter, I'm led by Senior Counsel Adidas. He's out of shift. It is not inconvenient. Can it be taken up on Monday?
Disciplinary appeal rules.
Your Lordship, inquiry
Not be a tough case, huh?
inquiry report has not been furnished to the petitioner in this particular case.
My lord, I have received the record, my lord. I will have to go through the records to assist the court. My lord, it may be taken up after 1 week, my lord.
Teams are complete in this particular case. Things are complete in this.
The pleadings are complete in the matter. Sir, ECCTL and a senior counsel assisted by
BB Khoyam.
counsel appearing for the respondent has submitted that the records are also available and he would require accommodation to go through the same. Accordingly, list this matter for hearing on.
Malord, that is on hearing date alone. May. 22, 29. Malord, 2nd June, Malord. 2nd June.
Can it be
2nd of June.
It is not in. 3rd of June, Your Lordship.
3rd of June is a motion day.
Your Lordship, 4th.
We are too full. 9th. No, 11th. 11th of June, sir.
11th June.
11th of June.
Deeply obliged, Malord. Tell me,
Please, Your Lordship. My lord, the petitioner working as a staff nurse in the Tejpur Medical College. My lord, during their service period, they have obtained the degree of BSc Nursing. As per ROP 2017, my lord, nurses with BSc Nursing are entitled to grade pay of 8,700, which are being denied to them, my lord. That is why before Your Lordship, my lord. And in a similar case, my lord, there's already an order passed by this court I'm relying on, my lord, which is at page 43, my lord. In similar case also, my lord, they were denied initially the grade pay of 8,700. This court directed them to pay that. Only were denied by the authorities, my lord, on the ground that when we join, we are not having that degree. That is why. Degree of BSc.
Now that you have joined, now that you have got the degree, you should get it.
Yes, ma'am.
And in this earlier case also, that is what the court has said.
Court has said initially, my lord.
In that case also,
court had directed to pay them.
The petitioners did not have the BSc.
No, my lord, they had the BSc degree
from the day one.
On day one.
When they joined.
Yes, my lord. But my lord, kindly see page 42.
Just a minute.
Respondent number 5 directed them, directed the college also. The person who has obtained degree during their service period may also be granted the benefit. Page 42, my lord. And there are some person, my lord, who has completed BSc after us are getting. My lord, by filing an additional affidavit, I have filed an one pay slip which I could.
Medical Standing Council DME.
Health.
Health and Family Welfare. Standing Council Health and Family Welfare. After some time, let someone come.
Lordship, in this case, I'll pray for 1 week of time, Your Lordship. They file I need to file a reply, Your Lordship.
Mr. R. Sinha, learned counsel, appearing for the petitioner, submitted that he has received a copy of the affidavit in opposition filed by the respondent authorities and would require a week's accommodation to
file the rejoinder.
File the rejoinder, full stop. Granting such time, place this matter again on 3rd of June? 3rd of June, 2026.
Deeply obliged.
Why this silence? Someone speak up.
It's a recruitment process.
Yes.
Our stand was that in this recruitment is only the SSC was made party,
Ah.
but the Lordship is very aware that the subsequent stages it is by the CAPFs. Here it is CRPF is the nodal agency and 2 petitioners, their medical conducted by SSB and Assam Rifles, which were not Arrears parties. And on the last occasion, Honorable Court directed us to file an affidavit by SSC stating that this is not maintainable because of not arraying the necessary parties. My present instruction is that there is another recruitment process of CTGD is going on and all the SSC officials and all the persons are at present is busy in that recruitment, so they want some time.
So why don't you file an impediment petition and overcome the hurdle? You don't want to.
Our stand is that they must file the affidavit.
Then you are on the ground of maintainability, it will be dismissed. Matter goes. We'll dismiss it now itself. Why do you need an
That is
affidavit?
for better for them if they made them party. That is what we are.
But
Do you understand this?
ours,
Do you understand the recruitment process, how it is done?
yes, my
Do
lordship.
you understand what is a necessary party?
Yes, my lordship.
What is
But
your
our terms is that the
SSC is a selecting party.
but the examination was conducted by SSC. Results were declared, and we have
Okay.
passed.
Heard Ms. K. Buragohain, learned counsel appearing for the petitioner, also heard Ms. B. Sharma, learned CGSC, who submits that she would require an accommodation of 2 weeks
More after vacation.
of, she would
Weeks.
require a further accommodation to file the requisite affidavit since the persons concerned are involved in other recruitment process. Accordingly, list this matter again on 16th of July. 16th of July 2026.
Please, Lordship, our affidavit filed, Lordship. It's not on record.
Hmm?
Lordship. Our affidavit has already been filed, but
When?
it is not on 18 of this month, Lordship.
And when did you find out that it is not on record?
It is, and
Today morning you found out that it is not on record. Then you should have told the, requested the court, call for it. We would have finished the matter.
however, Lordship, a reply also required in this. In our
No, no reply is required because as per their affidavit, Lordship, they have stated that I am entitled for the compassionate family pension.
Yes. Why don't you pay him? You got a copy, extra copy.
I don't have extra copy right now, Lordship.
Huh?
I don't have extra copy, Lordship, only one.
May I place it, Lordship?
Let us see. Compassionate pension, compassionate pension.
Compassionate
want
family
to pay
pension, Lordship. Compassionate family pension, Lordship.
That new scheme, na,
Yes,
2018 or
Lordship,
20?
2017.
17.
Yes. They are saying that they are processing by rectifying the errors of the pension proposal papers, Lordship. And shortly they will finalize it. In terms of that, Lordship, this repetition may be this work of Lordship.
Yes, any difficulty in disposing of the repetition? By taking on your, taking on record your stand. That she is entitled and you are processing and that you have assured that you would do it as soon as possible. So the court will grant you 3 months time to comply with or 2 months time to comply with so that you can pay the money. You are in this matter, Mr. Sharma?
Okay, for the AG.
The respondent number 3 has filed an affidavit saying that the entitlement is there. Compassionate family pension, this man will get, the family will get. They are processing it. We propose to dispose of the matter. Do you have the filing number of the affidavit?
Only one thing, my lord.
Do you have the filing number of the
See
affidavit?
the affidavit, my lord. In one paragraph, they say that the petitioner is not entitled to the benefits under the
Old
scheme.
pension, new pension scheme.
She would be entitled to the benefits under the new pension scheme. If that be so,
That be so, my lord,
he cannot be involved in the new pension
Who
scheme.
pays the compassionate family scheme, family pension? You will pay.
Here in the affidavit, they say that the
no.
is covered by the NPS.
And deduction was.
NPS is a separate issue and compassionate family pension is a total separate issue.
Both cannot go together.
Who said? How? Which judgment? How do you interpret that, sir? Compassionate family scheme is a scheme in place of?
Compassionate appointment.
No.
In lieu of compassionate appointment.
Compassionate appointment, not in lieu of regular pension. Regular pension continued. Additional compassionate pension, family pension.
That I was not aware.
If you go to the scheme,
Not good.
it says, in lieu of compassionate appointment, we will grant compassionate family pension. Now, it does not say that compassionate family pension will disentitle anybody from regular pension, but the regular pension scheme says,
Understand that. No, I was not aware of this.
what does the OPS say? OPS say, if you are drawing a pension, you will not get it here. So therefore, regular pension, since it is half the salary, compassionate family pensions is full salary. It is more than the regular pension. So they stop the regular pension and keep paying this pension. Not because someone disentitles someone. It is because only one pension can be availed.
Compassionate family pension manner, the petitioner's family will be getting the full salary.
That is why
the
the regular
age of
pension or NPS
60.
will not matter.
60. Then only family pension will
I've
come
not
after
seen that
that.
scheme.
So,
I am also entitled to the old pension scheme because my service was regularized prior to 2005, Lordship. They says that only because of submission
you
of
will
my.
not get both.
Get both.
You don't get two pensions
No,
plus pension.
now my payer is only for compassionate family pension, Lordship.
That is because it is more than the regular pension.
Yes.
That
Yes, the moment the paper comes, we'll process.
Your expression that how can they get both pension was also our impression. But when we went to the OM and we were pointed out that look, it's two different. One is for compassionate appointment only, not against the regular pension.
Correct. I have not seen the scheme.
It's 2017 scheme. One good thing is there, if one family member does not give the share to the others, they can approach the government and have their share taken. So they don't need to fight in the court.
Go through it, I have not seen that.
17 July.
An affidavit in opposition is stated to have been filed by the respondent authorities, a respondent number 3, wherein it is submitted that the entitlement of the petitioner to the compassionate family pension scheme is admitted. Full stop. This said affidavit is not found on record. List again on. Do not read yet.
First of the Lordship.
First week of do not read yet. On so and so date.
In the meantime, my lord, I will try to get some instruction from the director.
Affidavit filed by the respondent number 3.
I will try to get, because at the end of the day, my lord, I am the director, my lord, of the my lord, sericulture. So it will come to me. I will try to get any further instructions, my lord.
Learned counsel appearing for the respondents would be shall also have the relevant instructions in the matter.
The presence be recorded.
Yes, everybody's. You write. But Mr. M.K. Newg, learned counsel appearing for the petitioner.
I'm BC Musahari.
Learned counsel appearing for the
BTC.
Respondent number 3. Hard her.
1 and 2.
Number 1 and 2. Mr. B. Sharma.
The accountant general.
For the accountant general. Thereafter the rest of it. 5th of June.
Obliged.
29, I'm sorry, Lordship, I was in some other book. First, the proposal from the deputy commissioner we have received, and they have been prepared within a week, Lordship, we will send to the government, Lordship, for sanctioning the amount, Lordship.
For that period.
For that period, Lordship, the period those who are, my lord, the petitioner did not get the salary.
Okay. Mr. J. Hendrik, learned counsel appearing for the respondent number
1, 2, and
3 submit that the process for payment of the arrear salary as claimed by the petitioner is under process and would be forwarded for sanction within a short while. Full stop. Accordingly, he pays for an accommodation. Is this matter again on? We'll have it in July 1st week.
July.
13th of July 2026. On which date the learned counsel for the respondents shall apprise this court the progress in payment of the arrear salary of the petitioner.
4 and 5. Lordship.
Admitted arrear salary of the petitioner. Miss he appears for
First week of
so
July.
number 4 and 5 is
Lordship.
Miss Bhattacharya appears.
First week.
Lordship, fix it on Lordship.
13 July.
13th reopening.
Obliged, Lordship.
On the reopening, some happy news perhaps.
Lordship.
Order petitioners.
All of us. A disposal, a final bill, petitioners, everybody is happy.
Obliged, Lordship.
A health and family welfare মাতিছিল নহয় কোনবা এটা স্কুল দিব যে health and family welfare কোটে মাতি দিব Yes.
Yes, Lord, there is a office memorandum, Lordship, the third round of MSCPS, Lordship. It is, according to that office memorandum, dated 7/2/20. Date of effect of financial benefit to be allowed to the government employees from 1st January of the calendar years, Lordship. Lordship, may kindly address this.
So what is the difficulty?
Difficulty was,
At page 46 of their affidavit.
We just needed to know the correction.
yes, that is
1123,
already
1124.
clarified, Lordship.
What it should be?
It's clarified.
Okay.
Next page, the scheme is
Officer
there.
is appointed by so and so. 29th of January, you were appointed. Yes?
I was
Yes.
appointed on 4th February. Date of
4th
joining is
February
4th February
1993.
4th
1993.
February to 1993.
Yes, Lordship.
You joined. You retired attaining the age on 31/3/2024. She retired in the same post and position of so and so on 4/2/2020. But as per Approach Memorandum, benefit to be allowed a government employee on the 1st of January of the calendar year who completed
10, 20
30 years in the previous year.
In the 30 years, she will get the third benefit, Lordship. MSCPS. Yes,
24.
Then it will be 1124.
yes, 1124.
The scheme says this, listen. It is clarified that financial benefit under the scheme will be applicable from the 1st of January in respect of the government employees who completed 30 years in the previous year.
Okay.
Yes,
So you complete it in 23, get
23.
it from 24.
24.
Yes, now that they're processing it, we allow it to be processed.
Lordship, in respect of that,
Further?
Lordship, page 47, Lordship. The next one, Lordship. Affidavit filed by Health Department, Lordship. Lordship, I have obtained instruction, Lordship, that revised PPO will be issued shortly, Lordship. It is under process, Lordship.
We will wait till they complete it, my lord.
The TR Shamalan Council appealing for the petitioner present. Ms. D. Burrell, Learned Standing Council for the Health Department, has submitted that there is no anomaly in fixing
Yes.
the date of the effect of third benefit under the
MSCP.
third financial benefit under the MSCP scheme with regard to the petitioner, full stop. Mr. R.K. Talukdar, Learned Standing Council, AG, has submitted that the matter is under process for issuing a revised PPO in favor of the petitioner.
Lordship.
Full stop. Accordingly, council submit that the matter may be taken up
after 3 weeks.
After 4 weeks.
4 weeks.
By which time it is expected that the necessities would be completed. Yes. Accordingly, list this matter again on 20th of July.
Yes, well,
2026.
Lordship.
Obliged, madam.
May I please, your lordship? Your lordship, this is the latest uses that are there. With regards to that, your lordship, I would like to place before lordship that we would like to pay around 2 lakh rupees proportionately in accordance with the dues that are there, as soon as we receive the fund from the government.
No, how much? You are how many petitioners are there?
Lordship,
Four
four petitioners are there. One has been paid in full.
Now, you first petitioner, you owe 3,66,000.
Yes, your lordship.
Second, 135.
Yes, your lordship.
Third, 469.
Yes, sir.
And fourth is?
He's been paid in full.
He's been
He's been paid in.
So now 3 persons remain.
Yes, Lordship.
Out of the 3, what do you want to do?
We would like to pay around 2 lakhs each to the rest. Since one is having a less amount than 2 lakh rupees, that will be proportionately would like to pay around 2 lakh rupees each of them once we receive the funds.
Suppose, if you owe 1,35,000, why should you pay to?
No, like, no, Your Lordship, that will be proportionately, Your Lordship. If he owes around 135, he'll be paid in full 135.
He'll be paid 135.
The rest.
And the other two would be paid 2 lakhs
lakhs.
plus something.
Plus something.
35, 65. 32 each.
Yes, sir.
2 lakhs 32 each.
Yes, sir.
By what time? And what about the rest of it then?
Your Lordship, that I'm not aware of it right now.
Your name, madam?
PR Bangshari on behalf of SCDAS.
Counsel, the petitioner is present. Your name?
Your Lordship, Y.N. Mohanta on behalf of Mr. H. Omwa.
And counsel inform Mr. H. Omwa, representing the respondent contender, submit that efforts are on to make payments to the petitioner number 1, 2, and 3. The learned counsel has submitted that while the entire amount for the petitioner number 2 is being attempted to be paid in full,
Yes, sir.
due to paucity of fund, part payment is also being thought to be made in respect of respondent of petitioner number 1 and
3.
allowing time to the petitioner, the respondents to make the payments. List this matter again on. We'll have it end of June.
So can it be after the vacation?
13th of July. Immediately on the reopening, huh?
Much
13th of July 2026. It is expected that the respondents would comply with the orders of this court before the.
Much.
Contempt application, my lord. For willful and deliberate violation of the order. Page number 13, 6/2024. My lord, in the meantime, during pendency of the contempt case, my lord, they have filed and review, my lord, which is, my lord, already dismissed.
Review dismissed.
Review dismissal.
My lord, I am appearing for the director of pension, my lord.
These are my lord.
As per my instruction, my lord, no pension proposal submitted till that from the concerned
Who
department.
appears for the
Parliament even. In the cause is dead. All our respondent appeared, my lord, earlier.
Respondent
60 days. 60 days, PK Bora. 43.
Finance department, director.
एक नाम स्क्रॉल दीजिए बी देवरी बिटुपन देवरी बड़ुआ बी देवरी
On behalf of B. Dewey, my lord, I am appearing, my lord.
You are appearing on behalf of B.
Director of
Devi.
pension, my lord.
Then SMT Chisti and PK Bora.
PK Bora, my lord.
Scroll दीजिए item number display, court number display. After some time, you wait for some.
44 also my lord, contempt application.
Hmm?
Is all my lord, contempt application. Order is my lord, at page number 10. Regarding my lord,
Number
compensation
10.
An order of this honorable court has already complied with mine.
Is item number
44.
44 complied.
No, my lord, on la. Suppose my lord, this additional my lord.
SLC, Harry, please police it.
What is your name? What is your name? Meenakshi Borua.
My lord, Meenakshi Bora, my lord. Last occasion,
Claim of petitioner cannot be entertained for compassionate appointment.
on last occasion, my lord, disorder, no? Disorder, my lord, honest to this court, lordship, my lord, but there is some order, lordship, last order.
No, no. For your convenience. We are sending you the last date of when the matter was listed was in March. An order of April has been produced.
Lord, then, my lord, can you be my lord, so my lord, I will examine it.
My lord,
Give
I'll
me a
have
copy.
my
List again on Monday. Full stop. Miss. Are you there in the case?
Yes, my lord, for respondent two,
Miss
my lord.
Esutel, counsel appealing for
Respondent number two.
respondent number 2 has submitted that the orders of this court has been complied with by passing a speaking order dated 10/4/2026. The learned counsel shall supply a copy of the order to the counsel appealing for the petitioner for his perusal. List again on Monday.
Deeply appreciate.
I apologize, Lordship. Here, I'm
We
appealing for
need
the.
to increase the number of representatives.
No, Lordship. Here we have actually for the finance department also I'm appearing. Here we had filed an affidavit, Lordship, but it is not anywhere in the record, Lordship.
We have not received copy of.
No, Lordship. That it's not in the court record also. So, Lordship, I'll just seek some accommodation because I know we had received the file and we had filed it, Lordship, but maybe inadvertently it has been left out.
But Mr. S.K. Chakraborty, learned counsel appealing for the petitioner. Mr. A. Choliha, learned standing counsel for the Health and Family Welfare Department submits.
As well as finance, Lordship.
As well as the finance submits that an affidavit in opposition had been, that he was informed that an affidavit in opposition had been filed in the matter. However,
From finance department.
record does not reflect so.
Yes.
Mr. He has prayed for an accommodation to trace out the
Lordship, I'll also have a copy.
affidavit and have the same tag with the records. Full stop. Accordingly, list this matter again on
Need date as per my friends.
Lordship.
17th of June.
Lordship 17th on June, because in the meantime, I'll seek instruction from the health department also, Lordship.
Wait, please, your lordship. Here, my lord, impugn order is in page, my lord. Relevant page S26. My contempt petition.
Yes. Page?
Page 26, my lord.
26.
Yes, my lord.
Yes, 26.
Here, my lord.
25 is also important, my lord. Will kindly read.
Yes, my lord.
Certain directions passed by the Honorable Division Bench, my lord. Page 25, my lord.
Here, my lord. Earlier, my lord, same cause of action, there are 4 or 5 petitions was filed. Out of, my lord, 2 petitions were dismissed and thereafter they filed appeal. And that appeal, my lord, this order was passed, para 24. Subsequently, in this petition, similar order was passed along with.
You are required to complete a verification
Yes,
process.
yes,
Then
And if some people were found to not have met the eligibility criteria, my lords, we were supposed to put them to notice and thereafter proceed to terminate. That exercise we have completed, my lords. 6 people were shortlisted whose experience certificates were found to be invalid. 6 of them were issued show cause notices. Some of them challenged those show cause notices before this honorable court. My lord. Some of these show cause notices have been stayed. There are interim orders passed, my lords. Those writ petitions are pending. Out of the 6 candidates, my lords, 2 later on, my lords, when during the course of personal hearing afforded to them, were able to produce genuine certificates and they since have been retained. The issue now boils down to only 4 people, my lords. No, there are certain writ petitions pending. I'm
therefore
sorry,
you have
my
not been
lords,
able to
my lords,
consider their cases.
Yes, my 3 candidates, they were issued show cause notices. One has already been terminated. And that termination has also been challenged and it's pending before this honorable.
No, it is challenged, but it is, there is no stay operating.
As far as the termination is concerned, there is no stay operating.
And for the rest of the three where you sought to terminate them,
Yes, ma'am.
there
Those
is a
show cause
stay, you are not being able to proceed
yes, ma'am.
further.
Yes, ma'am.
And in case all the four go, then their cases will be considered.
Provided they, my lords, meet the criteria, my lords.
My lord, our
Yes.
my writ petition is separate writ petition. And but in this writ petition,
What is the order passed in your writ
in view
petition?
of the writ appeal, my lord. Along with my lord, now my lord here, the direction was my lord. Here, paragraph 4, third line. Under the above circumstances, we direct the respondent FEDCL to conduct a verification exercise of all persons who were appointed to the post of
Which part have they not complied, sir?
My lord.
Which part have they not
Yes, my
complied?
lord, I am, that is it. So, division bench, my lord, directed to verify all the candidates, my lord, total numbering 73 candidates, my lord. Out of 73 candidates, we have no grievances against 10 candidates. So, we 63 candidates, private respondents. And my lordship, I have filed an affidavit in reply. Here, lordship will find, my lord, what happened, how can they have verified their documents, only 4 people are fined, 4 candidates are fined, my lord, page 116.
You have a grievance of the process adopted. Is it in contempt?
My lord.
Is it in contempt jurisdiction?
My lord, while court directed to verify all the documents, though, my lord, there are 3, 4, 5 implicated respondents, but court directed to verify all the candidates.
Yes, in your affidavit, what are you showing?
My lord, page 116, my lord. My lord, I have given the list, my lord, along with all the documents. Here, 1 Minal Chandra Rai, my lord. Here and right side, my lord. As per advertisement, column 2-3, certificate regarding engagement 3 years from Concert Assistant General AGM, but experience certificate issued by Sub-Divisional Engineer, countersigned by AGM is not necessary as per advertisement. Work under contractor time to time. Contractor is not power utility as per the Electricity Act. I have given a short hint. Next, my lord, most important, next Tukon Chandra Shil, my lord. Here, my lord, I have highlighted this. Length of the experience is nil. Work under Anchalik Welfare Society. That certificate. Experience certificate, not counter signature. My lord. Next, I have given hints and all the documents I have annexed. My lord, next another thing, my lord.
So I have this.
You have this chart. There is a possibility that you would also know whether these persons, their certificates have been accepted.
My lord, the 73 people, my lords, their entire application, their candidature was inspected, my lord. Page 68 of my affidavit.
So
my lord.
now,
Yes, my lord.
he says that the experience certificate of Tukon Chandra Seal is not countersigned by the
AGN, Assistant General Manager.
Can you not clarify that part?
That I can do. my
That
lord.
seen and
Page 68, otherwise, my lords.
seen and done is that would put
perhaps
his
prevent it.
apprehensions to rest.
Yes.
And since there is a repetition, since repetitions are pending, the 3 posts will be vacant for filling up if the repetitions fail. 4.
Yes, my lord.
Top 4 who are now there in the list.
Yes.
Verify their documents, keep it ready. We close the content.
My lord. That exercise.
That keep ready can be done.
Yes, yes.
So yes, we have kept it ready. Now we don't have the post. Where do we put it? No content.
In fact, my lords, alleging non-compliance of the directions issued by the Honorable Division Bench,
Other contempts were there.
Contempt was also filed.
And that was closed.
Yes, my lord.
Then what do you have? Based on the same verification process, other contempt courts have been closed by the division bench.
In fact, no notice was issued in the contempt.
I am.
My lord. Yeah, but it's.
Weight is less.
My lord. Only.
Giving note of.
Next, my lord, on just.
Just a minute.
My lord, next line, my lord. Sharat Chandra Roy. What happened, my lord? Experience requires 3 years, my lord, only 9 months, my lord. My next, Sanjeev Devnath, my lord. Class 8 pass is required, my lord, not class 8 passed, my lord. So how can they have, my lord, verified the all documents, my lord, on only found the, my lord, 4 candidates? And where the division bench direction is given.
Put his anxiety to rest.
As my lord deems.
If possible.
My lords. Page 60 of 8 of my affidavit, my lords. Otherwise, my lords, I'm bound by what my lordship has fallen from my lordship. Page 68 is the reports furnished by the committee that was constituted, my lords, as per the directions. Para 2, committee on scrutiny of the document found that a number of 73 numbers of candidates were appointed as Sahayak by office order of so-and-so, so-and-so. My lords, on proper scrutiny, thereafter at the bottom of the page, educational documents and experience certificates taking into consideration notice published in the newspaper so-and-so, dated so-and-so, following candidates were found with invalid experience certificates, my lord. So it is not a case that the 73 were not scrutinized. All of them were scrutinized, and these 6 were found to not have valid experience.
Out of 73,
these 6 were found to have
66 appeared. 66, 67 appeared.
73 were appointed, my lords.
And 67 appeared.
Yes, my lord.
Before the committee.
Yes.
And that is why, my lord, how the committee, my lord, again re-verified, but this, which is I have, my lord, mentioned with the documents. How can they have verified? Suppose one candidate is not past 8, but that, my lord, disqualification not identified by the that committee, my lord. How can it is possible, my lord?
It must
My lord, 1 year,
must be a chart.
11 months.
Verified, my lord.
There must be a chart.
Only,
if possible, give us that. We put his agitation to rest.
only, my lord, direction will given. I have gauged the election along with my reply affidavit. All documents I have annexed. What they want to say, my lord. The verification committee. I submitted against that is the perfunctory verification.
That is his
Perfunctory verification, my lord, because where class 8 is required, man, they have he had not passed class 8, he have appointed servicing about from 13 years, and that verification, high power verification committee could not identify that candidate. What kind of verification is
You have
going?
filed your affidavit in the matter?
Yes.
Just clarify this part. When?
Some time may be granted, my lord.
Your wish.
After 4 weeks, my lord.
4 weeks.
Yes.
Date may be given.
Learned counsel for the petitioner has pointed out certain discrepancies in the verification stated to have been carried out by the respondent authorities. Mr. Chaudhary, learned counsel appearing for the respondent, opposes the same. Full stop. Place this matter again on 25th of June, by which time Mr. Chaudhary shall inform this court. No, shall have his instructions on the discrepancies pointed out by the learned counsel for the petition.
My lord, page 16. Oh, I have all documents. Which have I got
Please
from
noticed
the
that
RTA.
the respondents have taken a specific stand that the verification had been carried out and petitions alleging and contempt petitions filed alleging that the verifications had not been carried out have already been dismissed by the division bench of this court. Yes.
Deeply.
I'm sorry, Your Lordship. Lordship, item 29 has been postponed, Your Lordship. Otherwise, I am ready with the rule, FR and the judgment. Item 29, Your Lordship.
কেতিয়ালৈকে দিলো? What's the rule?
I have a judgment also. 54, FR 54, 3, B3 and B8, Your Lordship. FR 54. B3 and B8.
Page? What is B3? B3 of what?
FR 54
FR 54.
B3,
Hmm.
page 106 and B8, Your Lordship.
What does it say?
Where the authority competent or order reinstatement is of the opinion that the suspension was wholly unjustified, the government servant shall, subject to provision of sub-rule 8, be paid the full pay and allowance which we would have been entitled had he not been suspended. And rule E8. Okay, I have
7, 8.
judgment also in this line.
It is said too little, too late.
See.
What did you say? They are processing it, na? Mr. Jehindi appeared. They are processing your case for payment. So we have given them some time. Otherwise, you should be ready with this.
I'm grateful,
Otherwise-
Lordship.
Huh?
I'm grateful,
Too little, too late will not work always.
deeply obliged.
Ah.
I'm very sorry, Mala, I'm not. Sorry, Lordship, when matter was called.
What was it?
Here, my lord, contempt, my lord.
You are sorry that you have not complied.
My lord, no, my lord. Actually, we have filed a review, my lord.
Review is dismissed.
Dismissed, my lord.
Now, you are filing an appeal. Not yet. Has it been filed?
No, my lord. My lord, 1 week time may be granted.
What was the, this thing?
Direction was.
Direction?
Start from page 16, my lord.
What are you required to do? Just tell us that. Husband petitioner terminated Dhemaji Amrit Prabha Datta, not by me, before any other bench. List this matter before a bench without me.
Bless.
Deeply blessed.
Wait, the Lordship. Lordship, as per last order, Lordship, the respondent BTC was supposed to complete their instructions.
Yes, Lordship, I have received instructions.
What is your case?
Lordship, we have challenged the appointment of the respondent number 6, Lordship, as an Anganwadi worker. Lordship, our contention is that the respondents belonging to the OBC category would not have been selected from the particular center which was reserved for the general category, Lordship.
Is there something called reserved for general category?
Lordship, as per the advertisement, Lordship.
Huh?
On merit, serial number.
Lordship, there's an advertisement of the Lordship,
one?
page
Page
20,
14?
Lordship. Lordship,
Page 14,
page, it starts from page
13.
13, Lordship. It's a type copy. Lordship, the terms and conditions is at page 20.
Which center?
Lordship, Hilapar, Lordship, 11 at
Hilajar.
Hilajar, 11.
11.
11.
Ah.
Reserved for
So
general
that-
category.
No, it was open. There is nothing called reserved for general. How can something be
No,
reserved for
Lordship,
general?
Lordship, turns to page 20, Lordship. There's a terms and conditions which says, Lordship. No, Lordship, page 21, the selection procedure. Lordship, serial number 2. If more than 40% of the population in the particular area belongs to SC, ST, OBC or T tribe, priority will be given to candidates from the same community. In this particular center, Lordship, the population majority is not more than 40% for the SC, ST. That is our case, Lordship. Otherwise, Lordship, it depends on the instruction what they have got, Lordship. That is my case.
Private respondent selected on merit, Lordship. Private respondent.
Should we allow them to bring this by way of an affidavit, Lordship, if I counter?
I will find.
Your name is Mr.
P. Das.
E. Das, Learned Counsel appearing for the petitioner. So heard.
BC Musahari. SC
Appearing for the
BTC.
respondent BTC.
BTC loss.
I'm responding 1 to 3 Lordship.
1, 2, 3. 3. The counsel for the BTC has submitted that the instructions have been received. আগৰ পুৰণা contempt যে চৌধুৰী appear কৰিছিলে. Instructions has been received and he will be filing an affidavit in opposition. Place the matter again on.
A short date maybe.
Why?
There's some urgency, Lordship. I'll try to. Lordship, as the matter is disposed of early, it's better for everybody, Lordship.
After 2 weeks.
Early disposal. Choose a date.
After 2 weeks.
After 2 weeks, to file the affidavit in opposition. Instructions take back to instruction.
Yes.
10th of June.
Lordship. I'm obliged, Lordship.
Yes.
As per the office note, it shows that neither the ID card nor the report has been came back, my lord. But in the meantime, my lord, the respondent content number 1 has been changed. So the new person has come in. So I have to implement him as a party.
List again on the 8th of June. No, we'll keep it on 12th of June, 2026, awaiting service report on the respondent number 1 and 2. You file your implement petition, should be recorded in the order.
Yes.
We have given you
Yes.
enough time. have you?
No. That's why I
Okay.
informed that I have to implement the ceremony party.
Therefore, 8th of June.
Or lordship.
Yes.
Your Lordship, I am appearing for the first time, Your Lordship. I have received instruction. His
You
name has
received?
been placed in the DLC and his name has been rejected because of he has not applied within 1 year. This is the instruction. Parawise comment I have received. In paragraph number 7. I can file affidavit also, or Lordship can go through this.
We have not been intimated, my lord, this development as per order.
You are intimated now.
Will
You are intimated now, she would give a copy of the rejection. You have the copy of the rejection order
Yes,
by the DLC?
yes,
Give me a copy. No, that order by the DLC.
yes. It is.
Resolution of the DLC, give me a copy.
Resolution of the
Heard Mr. M.J. Kari, Learned Counsel appearing for the petitioner. Also heard Mr. Fukan, Learned Counsel appearing for the sole respondent.
Yes.
Ms. Fukan submits that the matter of the petition.
I will go through it.
Go through what?
Yes.
They were required to place it before the DLC. They have done so. It has been rejected. Challenge it.
A copy should be given to me
We will record it.
to furnish a copy.
Yes. The Learned Counsel appearing for the respondent number 1 has submitted that the matter had been placed before the DLC, which has rejected it by the resolution taken on date.
Date is on. Date is not mentioned.
In the DLC meeting. Full stop. The Learned Counsel for the respondent has agreed to serve a copy of the minutes of the DLC meeting to the Learned Counsel for the petitioner.
Held on 16/3/2025.
DLC meeting on
16/8/2025.
Supply a copy of the DLC minutes to the Learned Counsel for the petitioner. Since the case of the petitioner has been proceeded further in accordance with the orders passed by this court, we do not find any contempt to have been committed. Full stop. Accordingly, the contempt case is closed. This closure shall not affect the rights of the petitioner to approach the appropriate forum of law against the for any other grievance.
Obliged.
An application for amendment, my lord. Because earlier petition, my lord, I have missed the retirement, retirement gratuity amount, my lord. Is yet to receive by the petitioner.
Allow the amendment.
Lordship, I am appearing for AG, respondent number 3.
If others don't appear, what can we do? We can go Bring them here. If you have any objections, tell us.
GPF already given during dependency of the case. That was the only, I am receiving my regular pension now. A death cum retirement gratuity was left out.
Any affidavits filed in that matter?
In that case, my lord, no matter, they have given me the instruction, my lord, already received the amount also. That is why I have specifically pointed out that you have not paid for. But annexures were there, but I have not specifically paid for. That is why. That is also tagged with it.
Finance, irrigation, you are AG.
AG, your lordship.
They have given
Finance,
range.
irrigation, and pension. Scroll to deduction. SC finance, SC irrigation, SC. Finance, irrigation, or pension.
Pension.
Oh, video. After some time. $52, $52.
50, 51, 52.
What's it? 52A, 52B. Yes, sir.
But I have filed an IAM here for amendment of the prayer, my lord.
Huh?
For amendment of my prayer, my lord.
Prayer.
Yes, my lord. But,
Heavy objection. Heavy objection.
but my lord,
You can't go on adding prayers. One prayer allowed, second prayer, again second prayer allowed, third prayer.
only my lord, really, the entire case was that this is a systematic discrimination. If they say there are three categories of PWD, not two, PWD, PWBD, PWD having with high support need. Three
With
high support need.
high?
Support need.
There is one with a person with disability who does not need any support. There is one
Having high
PWD
support.
who requires some support.
Yeah.
And then there is a PWD with high support. Okay.
There are three categories of PWD. There, what happened? The structure has been framed when putting the benchmark in focus because the disability is not the medical disability here. If they will say that no, there is no reservation for PWD and PWD having high support need, then it will be violation of the Article 41. And under the Act, my lord, there is a provision for punishment. If any Act, rules, regulation violate, then and in PI.
We are not able to understand you.
My lord, if here, my lord, they frame the rule, recruitment rule, but Rule 20 says, or Section 20 says in the Act.
You are presuming that we know your writ petition.
Yes.
Your prayers there or your arguments there, and then you are arguing. No, we know zero of it. What is the prayer of the writ petitioner in the writ petition? How did it start?
I entered we appeared the selection process.
Yes.
Entire selection process has gone.
Yes.
And I issued an appointment order.
Okay.
Now, when time come to join, the director issued an order holding my joining.
It was held up. Then
I came to before this honorable court. But there is an interim order by this honorable court to act upon the appointment order. But they have not filed any.
There is a contempt.
Yes, there is a contempt. But they are not showing the reason justifying their action, that why I will not be given the opportunity.
What is your disability?
My disability.
In any case, it is for the post of Chokidar. Then?
Yes.
Now, why do you want to amend the prayer?
I amend the prayer, my lord. Additional prayer.
You want to have reservation not only for person with disabilities. Your argument is that there should also be a reservation separately for person with disabilities requiring high care.
Actually, the part pass, my lord, my lord.
We are not on the justification of your
Yes.
prayer. We
Yes.
are asking what is the prayer?
Yeah,
The prayer is that
yes,
not only for PWD, but there should be a classification there also.
yes.
Is that your prayer? What is your prayer?
My prayer is amendment. I want to need, my lord. So if there says that there is in employment opportunity, my lord, only PWBD, only for reservation for PWBD, not
You
for
want?
PWD or PWD having high support needs. They are saying.
You are saying that the advertisement is wrong because it does not contain a reservation for PWD
PWD,
and PWB.
PWD having
PWBD.
high support needs.
There is no reservation for them.
Yes, they are saying, but they will not say that there is no reservation. They will say there is a reservation. If they say, well, systematic discrimination, there is a new concept came to tackle with these acts, because if your lordship see, they advertise, PWD are invited to apply.
You object to the amendment?
No, sir, I have to take instruction. Actually, they are challenging one notice where medical board had called them for re-verification of their disability.
That issue is either already
Lordship.
in DB, my lord. And if your lordship, my lord.
Heard Mr. S.K. Roy, learned counsel appearing for the petition. Also heard you appear for all.
No, your lordship. I am for social justice and empowerment department. Actually, health is the main party here, your lordship. They have called them for medical re-verification in spite
Miss
of.
so-and-so appears for the respondent number.
I am for
opposite party number
1, 3, and 8.
Cannot. How can you appear for one?
Oh, no, your lordship, not 1. I'm sorry, your lordship. I am
Appearing for 2,
not
3.
2, your lordship. I am 3 and 8, your lordship.
3 and 8.
Yes.
Now who appears for 2? Oh, no, who appears for you are appearing for only 1? Miss so-and-so appears for number 1. Then who appears for 3? No, 3 you are appearing.
I am appearing. Oh,
Or
lordship,
just a
elementary.
minute. 2, who appears for 2?
2 personnel government advocate.
কোনটা কেন GA?
Personnel department.
পুরোটা কোনো নাই, প্রাইভেটও কোনো নাই।
Department.
It's GA আসাম হবো। Regional Council for the applicant has submitted that an amendment to the prayers made in the parent writ petition being WPC number
Medical board.
WPC number
674.
7 and 9 হবো আমার।
6741 of 2023 would be necessary for proper adjudication and grant of relief to the petition. He has prayed that the proposed amendments are available from paragraph number 4, 5, 4.
Only 4.
And the
After amendment.
and after amendment, the prayer of the writ petition would be as follows. You take from paragraph 5, huh? Page 8 of the page 8 of para 5, IA 1629 of 2026, huh? Issue notice. Respondent number so and so are presented. Extra copies to the councils representing the respondents within a period of 3 days from today. Extra copies on the standing council for the other respondents. Number. number. What I request again. Respondents number, yes, sir, help us to keep on.
1 to 9, my lord.
For 4, 5, 6, 7, 8, and 9. No, here you go. Under respondent number 4, 5, 6, 4 and 5 to be served to the Standing Council for the Department of Elementary Education. Notice on the respondent number 6 to be served through the GA Assam. Notice on the respondent number 7 and 8, 7, 8 and 9 to be served through the Standing Council, Department of Health and Family Welfare.
Yes.
List again on when will you have instructions?
Lordship, after summer vacation.
15th of July.
Like.
Yes.
Just only to include the my lord, the debt cum retirement gratuity, my lord, it was left out. Though although it
find
was
the other councils.
Lordship?
You could not trace the other council.
No, my lord, no, we did. I've seen. But at the time of when it was last listed before my lord Justice K. Nair, my lord, his honorable court, my lord, observed, my lord, to file this. They were not objected because, my lord, they received the instruction also. But as that was not my prayer in the petition, that is why I observed that you file one amended petition amendment.
Is the Senate Council appearing for the petition? Also heard?
Lordship, I'm M. Das, appearing on behalf of SK Midhi for respondent number 3.
Respondent number 3. You would respondent number 3 will take action only if the other persons are there. None appears for the other respondents. Although all are represented by their standing council. Although all have their appointed standing council. Is the matter again on Monday. Did you get it? In conclusion, this writ petition succeeds. The order passed by the Director General CRPF and the letter dated 1/2/2019 issued by the DIGP Group Center Silchar are set aside, and the respondents shall process the claim of the petitioner for the grant of ex-gratia compensation without reference to the grounds for reject claim earlier, and shall ensure payment of our entitled ex-gratia payment within a period of 3 months from the date of receipt of a certain judgments we are trying to put into this.
Yes, sir.
That will take some time. You'll have the copy by Monday.
Yes, sir.
Monday
As
or
your lordship
Tuesday, you
pleases.
should have the copy.
As your lordship, please. Much obliged, your lordship.
Unfortunately, we have not got that copy from inside now because we have continued, but otherwise, we are setting aside the diaslon part for the no pay, no work, no pay that is being upheld. However, the other consequential benefits should be there.
Other
The continuity of service and seniority, etc., would be there. Diaslon goes. Payment of actual arrears will not be there. We had asked them to put in a few judgments. They're just having a copy of that. You'll have it by Monday. Otherwise, that is the order. You'll have it on Monday. Thank you.